Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host. I'm your amicable host, I guess. Maybe I'm not amicable. Maybe I'm prickly and rude and off-putting or whatever. It depends on who you are, I guess. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How are you guys? How's it going? It's been a day. Been a day. That's the thing. I feel like I'm all out of sorts here. But it's been a day for sure. What is even going on? Where's my tea? Oh my gosh, hold on. It's right here. All right, there we gotta have the tea. Gotta have the tea. A little bit later, we'll have the sauce. So, yeah, man. I don't know about you guys. I'm just trying to get back into the swing of being at home. You know, repairing all the disasters that happen when you go on vacation, because you can't pause everything. That would be convenient. But no, can't do it. So you gotta fix everything that breaks. Oh. Okay. Someone asked how am I? I'm getting everything organized here. I'm disorganized. We've got actually nothing important has changed as far as solo streams go. So I'm not going to actually whine about that. But with the combo stream with Ty, I mean, I think we got it working just fine yesterday. So let me explain that real quick, and then I'll lead with my mistake after I do my little exposition here. Because so if you guys don't know, because like you don't do YouTube or whatever, YouTube had this cool thing called Hangouts on Air. It's an old Google program. Now it looks on the surface a lot like Hangouts, and you may think that they're the same, but they are not. They're not. Hangouts on Air had this great feature where if you had two dummies talking to each other, then when one talks, their face shows up, and when the next dummy talks, their face shows up, and it does this switching thing based on microphone input. It's very clever and very handy. And nothing else actually does it. None of the other chat programs that I've seen. Skype doesn't do it. Discord doesn't do it. Regular Hangouts doesn't do it. Nothing does it. Just Hangouts on Air. But then Google says, why would we want to have Hangouts on Air for people? Who cares about that? Let's just get rid of it. And suddenly, no more face switching. So what I had to do is I had to actually have two cameras, one on me so that Ty could see me in the Hangout window, and one that was on me so that it would pick up that feed and put it into OBS. Ridiculous. Hangouts does not do the face switch. I'm telling you. I think it might if you have more than two people. But it's really, really annoying. So anyway, that was the fun thing yesterday. Trying to get that set up was great. It's great. Oh yeah, Discord does it by highlighting the talking person green. There you go. But that doesn't help you with like this. So what you have to do when you have like OBS or Streamlabs is you have to capture the window or a portion of the screen or whatever that's got your Hangouts in it, and that's you feed that in to OBS, and that's how you do the nice screen switching thing when you're chatting with someone. But you can't anymore. I'm not make a macro for it. No, I don't want to macro and switch between people manually. I'll be sitting there doing this all day. Oh God, horrid. Anyway, that's enough whining about about OBS. We got it working. I have 2 cameras. It's really not that big of a deal in the long run. I just had both cameras, and it was fine. But let me go ahead and lead with my mistake. One of my policies is when I am, when I find, most often this will happen if someone lets me know, but if I find out that I'm wrong on something, I try to lead with it. Now, I have been wrong about something for a long time, and I want to correct it, even though it doesn't really matter. At this point in the Mignogna case, it doesn't really matter. But I had a miscommunication with a source. And so because of that miscommunication, we were saying 2 different things, but both translating it in the same way, which led to me being incorrect about something. So I want to clarify that right now. The TDMA letters that were sent out to Ron Toye, I was informed that there was an individual, like, either letter or paragraph or paper or something for every single tweet that Ron Toye sent out. That's what I was told by my source. And it turns out that that's not the case. Okay? So what happened was there was a letter that went out on the 12th. For Ron, it's about 5 to 7 pages. And Monica is like a page less or something like that, or whatever. And they each got those, and then they got an attachment with some offending tweets and stuff like that. Ron's attachment, of course, was the 370 tweets that I was going through that are out there. He had the initial letter and then the 370 or whatever, I think 376 pages on the PDF of tweets. I was attached to that, so it's almost 400 pages. And I was under the impression that it was an individual letter for each one. Now it's not. It's that initial 7-page letter plus the tweets in addition. Why does this matter? Here's the roundabout way that it could matter. So the TDMA requires you to argue or to basically point out with some specificity any of the offending communications that you're demanding that you're requesting to be clarified, corrected, or retracted. Right? So this is a weird requirement of Texas law. Some other states have similar things. It's a dumb law because think about this. If I go to your boss and I say you are a pedophilic rapist and your boss fires you, now you find out that I said that and caused that, and so you want to sue me, so you have to then send me a demand that I retract, correct, or clarify that statement to your boss. Well, you're already fired. How much damage are we actually mitigating by doing it? So it's kind of a weird thing. I'm not a big fan of it. I think maybe years ago it might have been maybe able to curb stuff, but on the internet, the damage happens instantly, and the information spreads quickly. So in this case, like even if Ron went and deleted all 370 of those tweets, would it matter for Vic? No, the damage is done, right? There'd be no major benefit in doing that for Vic. But so the requirement for the TDMA is that the statute is poorly written, of course, but it basically says that to maintain a cause of action for defamation, you have to send out these letters. And then it says, and if you don't send out these letters, you can't get exemplary damages. Exemplary damages basically triple the amount of damage that can be linked to the defamatory statements. So you definitely want exemplary damages, and you definitely want to avoid them if you're the defendant, right? So how you avoid them is simple. You clarify, correct, or retract them. Let's contextualize this. Wait a minute. Is Ty in here? He is. He is. What's up? What's up, Ty? I'll add him as a moderator so I can see when he's yakking. So here's the thing with those TDMA letters to contextualize how this functions. And we talked about this a while ago, but I'm gonna re-hit it now because this is why it matters. So if Funimation, they make their tweet, right? They're 3 tweets. So a TDMA request goes out to Funimation. Now, if Funimation abides by the TDMA request and either corrects the statement and says, for example, they say, actually, Vic Mignogna is not a sexual harasser. We understand some people might have been confused by our tweet, but it's... We understand people might be confused by our tweet, but we want to clarify he was not fired for sexual harassment or assault or anything like that. That's a correction. Clarification is basically the same in this case. Or retraction, which says, we retract this statement. It was sent out without authorization or whatever and should not be out there. We want to retract it. And then they delete the statement. Any one of those things, and picture this. They take whatever damage award they'd be liable for and basically cut it into a third. They cut it into a third. So if they're awarded, well, the way it would work would be, let's say they award Vic $200,000 for Funimation's tweets causing damage. Well, Vic gets $200,000 plus exemplary damages of $400,000, so he gets $600,000, right? That's how that works. Now, all they had to do was abide by that TDMA letter, and that 600 turns back into 2, period. But they didn't do that. No one did it, as far as anyone can tell. And I think if you do it, you have to also, if you do that, you have to also like notify the other party and serve notice of the clarification, all that stuff. But anyway, so it didn't happen. Why does it matter that I was incorrect about the number of tweets in the letter? Well, one of the arguments, hold on. One of the critical parts of this letter is the request for the TDMA. The TDMA request has to be sufficient and timely. So it has to be served on the other party within 90 days of the discovery of the published statement. And then it has to be sufficient. And there's a checklist of 5 things to make it sufficient. The long and short is it basically has to clearly identify the statement, when it was made, where it was made, and why it's defamatory. Okay? So the argument could be, for example, that the TDMA letter that was sent out for Monica and Ron, or particularly Ron, he would be the particular case. You could argue it's insufficient because you have 7 letters with some summaries of some tweets, and then you have 370 tweets attached to it. So you could make the argument that is not sufficient notice of the defamatory meaning of all of these comments, and you could try and attack them and get them removed, therefore limiting your damages in that way, or maybe even limiting your liability. Now, from the service of the letter, you have 60 days to challenge this, and to challenge it, you have to make an objection by motion. You have to do a motion to challenge either the timeliness or the sufficiency of the TDMA request, or both. You have 60 days to do that, and it has to be by motion. Now, what Casey did in the answer to in Monica and Ron's answer, maybe I should pull this up. I could just show you. Where do we got it? Here. Pulling it up here. One moment. One moment, please. There we go. So they go through, here's their lovely answer. So they have their general denial here, and then they have their verified denials. Here in paragraphs 20 and 21, They argue that it doesn't comply with the TDMA right here and right here. And then here they say specifically deny that plaintiff's request was served on the defendants within 90 days after learning the publication, which is silly because it absolutely was, but okay. Either way, these challenge the sufficiency of it. But anything, sufficiency and timeliness are all right here in these 3 paragraphs. The problem with this for Casey and Monica and Ron is that this is not an objection that is raised in a motion challenging the sufficiency or timeliness. So this is why I say it doesn't really matter ultimately, because they've waived their ability to challenge the timeliness and sufficiency of the letter. But they could have potentially done so. Now, would it have been effective? You're going to stand there in front of a judge and say, Judge, they sent me this letter with 370 tweets, and they only talk about 8 of them specifically. So I don't know what the other 362 tweets, I don't even know why they're there. And the judge is going to say they're there because they're alleging they're defamatory. You know, you've been given notice of these things and all of that stuff. And the remedy for it, again, would simply be probably just be a loss of exemplary damages. In theory, it could dismiss the action. I think there's been one ruling like that, but they're pretty rare. Pretty rare. Anyway, so it's the long and short is I was wrong about exactly what was sent out as far as the letters go. I don't like being wrong. I don't like being wrong about stuff and having you guys have incorrect information. So I'm clarifying that now in the biggest platform I had. I did mention it in a discussion on Twitter today when someone had asked me about it, and they asked me about those letters. And so I went and verified the information. And once we got it cleared up, the communication was clear, I realized that I had the wrong info. So here I am clearing that up. That's my policy. I will always bring to you my incorrect info or mistakes as soon as I can verify it. Absolutely. So there you go, guys. And to his credit, MD McCullough and I had a very nice discussion about it. So good job. Good job, MD McCullough. So there's that. All right, what's next? Oh, I got some real fan mail, not like a ethics complaint fan mail, like fun stuff. So I was going to show you guys that real quick. First, this is a preview. I'm saying it now because the best policy on running a YouTube channel is to say things that you'll regret. 75,000 subscribers. I will eat one of these. That's, yeah. These are Carolina Reaper pods. I'm gonna regret it heartily, but we're gonna do it, I guess. 75,000 subs, which is coming up. We're at like 73 right now. So, it's 75,000. I hear they burned twice. We'll find out live on Rekieta Law. So I'm gonna be eating spicy stuff to kind of prep the colon for it. We'll see. What do we got here? Okay, this one comes with a letter. So this is, hey there, Rackets. You can read this out on air if you want. I don't mind either way. Well, good. I'm a big fan of yours, and I decided to show some gratitude for all the fun and interesting stuff you do. I'm a student, so I save money where I can. I hope you understand. Well, of course. So here's some stuff I made in my spare time I hope you appreciate. I found you through the Dick Show, but not actually through the LOL suit. I think it was the Demore suit against Google that I first listened to. You have a way of explaining things that would otherwise be dull that I really enjoy, and I kept up ever since. I'm in a trade program for carpentry, and your massive catalog of streams gives me something new to listen to while I shop all day. While I'm in the shop all day. Sorry. I've actually broken down laughing at Drexel screaming, "Who hurt you?" And that's an accomplishment on his part. I think it's great that you will have anyone on the show. You actually act like an adult and don't just blindly hate the other side. And as a guy in college, let me tell you this, that is in shorter and shorter supply, but that is mainly just college. Still very annoying though. It's not just college, buddy. It's not. Enclosed is a knitted Adeptus Custodes banner and a top that I turned. The top is just plain old maple, nothing fancy. I hope the kids and or you enjoy it. Keep up the good work. Sincerely, Civilian of the Fandom Wars. So here's the top. It's a top, spins, you know. So that's cool. And then this is neat. This is the knitted Adeptus Custodes banner, which I like. That's great. Thank you. Fantastic. So there's that. What do I have here? Is this the one? Okay. This is from Mark. I'm not gonna say last names. I don't want to do last names. Mark sent me this, which I'll open in just a second. Please find the enclosed pen and presentation box for your enjoyment. I'm not gonna read all of this, but this is a pen, and the pen box are made from whiskey barrel oak. So they smell like bourbon. Here's the pen and the pen box. Both are made of whiskey barrels. So that's awesome. Thank you so much. I really appreciate that. That's cool. Cool stuff. And I love having the smell. The smell of wood soaked in bourbon or whiskey is different than it doesn't have the acetone or gasoline-y sort of burn. It's just got the pleasant aroma mixed with the wood. It's great. Great. All right, I got this one here. So this is from Sam. It says, I know you don't have a lot of time for the hobby aspect of 40K, so I whipped you up a squad of dudes you can easily take with you and jump in on any game. And he sent it in this humidor. But this is a squad of custodes. Very cool. I really appreciate that. These are all excellent. Thanks, man. I really do like it. I've gotten to play Kill Team thanks to my man Marty, and it was a lot of fun. I'd like to play it again. I'll have to bring these guys to a convention just in case somebody else is there. So if you're going to see me at a convention, you want to play a game of Kill Team, bring one, and we'll do that. Finally, for now, this is how you know you're a real lawyer. Real lawyers get trophies. Fake Twitter lawyers don't get trophies, because only in real law do you get trophies. So this is a trophy here. It says Nicholas Rekieta, Ultimate YouTube Lawyer Weeb Wars Champion. So that's that. And then there's one more. 2019 YouTube Super Lawyer Most Salt Harvested. So that's a special award. These are both from Short Round. Thank you, Short Round. Very much appreciated. So that's that. That's thank you all. If I've missed something, don't worry, I'll get to it. But we need to move on. We need to talk about Meyer versus Waid. Very big, important updates for Meyer versus Waid, and they're not unsurprising updates, by the way. I think if you go back and watch what I thought would happen, it did. So we'll talk about that. We'll go through the orders and what it means. and we'll probably just kind of wade our way into Vic stuff. But first, of course, I'm going to do the super chats real quick that have come in. Mongo5817 says, as a patient recovering from West Nile poliomyelitis, I hereby allow, condone, and endorse any and all West Nile jokes that West Nile Chan has made or will make in the future. It's open season, boys and girls. Salivate on your proboscis and get prickin' skin, y'all. It's time to infect. GR People says, just tagged you on Twitter. Seems there's an Amber Alert in Texas worth spreading. Okay. Nick's Hex says, Nick, if you read it led me to being incorrect out loud, I could just hear you saying an attorney definitely wrote that and laughing. If you read it led me to being incorrect out loud, I could just hear you saying an attorney definitely wrote that and laughing. Did I say it led me to being incorrect? That's, well. Mithra and Emra says, who knew Alexander Pope read law Twitter? A little learning is a dangerous thing. Drink deep or taste not the Pierian spring. Their shallow draughts intoxicate the brain, and drinking largely sobers us again. So there you go. And then Mike Walter says, during your deposition, Monica mentioned that Sentai Filmworks had banned Vic from their property. Has there been any verification on that or not? Was wondering because from what I have seen, Sentai has stayed fairly quiet. Let me just say this to Monica. Citation needed. Citation needed. I think Vic just did a project with Sentai last year at Sentai. So I'd be surprised if he were banned by Sentai. And, it's another one of these phantom bans. Well, he's banned, but nobody says it. But he just is, though. He just is, though. So you just have to listen. Like, if you're a lying, Geiga Jaw, you say that he was banned from conventions, where, of course, he comes back to the convention and what? But he was banned. Why is he back? Maybe he wasn't banned. Maybe no one banned him. You just thought he was banned because you're an idiot. Maybe. I'm gonna cast my line and just hope that maybe it pulls in the answer that you're an idiot. I guess. Wow. No, so far I have seen nothing to support Sentai banning Vic from the property. And my sources so far say that's not true. That's not true. Your art is trash says, if you and Ty hit ABQ, I think Albuquerque, for Bubonicon, which is a lot better than it was 10 years ago, I'll buy you both dinner. Cheers with some Jameson to the two of you for being brilliant. P.S. I now work compliance for National Financial's parent company. All of their software sucks. It does. It does. Absolutely. Yeah, Tess, you do need to get to Minnesota. What are you doing? Why aren't you already in Minnesota? Jason Ta says, hey, Nick, just popping in on my birthday. MCAT study has been tough, but the laughs on YouTube and Twitter make everything better at the end of the day. Any recommendations on drinks now that I'm of age? Also, you ever coming to California? Oh, man, I need to. I want to go visit Larry and Dick Masterson out in L.A. But, oh, and Keon, you know, he's there too. I would love to go out there, but I'm traveling so much this year, I don't know if I can do it before the end of the year. We'll have to see. Who knows? If I do, if I'm going to go out there, I'll announce it. Let's see. What else was there? What else was I going to do? Oh, speaking of Dick. Dick Masterson is going to come on the show Monday night. We're going to talk about Vic from a marketing and PR perspective. Dick Masterson owns an SEO company. and had some polite thoughts for the lawyers who said that Vic should have just hired a PR firm to take care of his issue and not sued anybody or anything like that. PR firm would have fixed everything, of course. PR firms always fix everything, except when they just really haven't been that effective lately. But yeah, so he's going to come on. We're going to talk about that. We're going to discuss Road Rage Minneapolis. Road Rage Minneapolis is what is it? August 17th, right? August 17th is Saturday. Guess I should double check that. It's that weekend. I believe it is. Oh, weird. If you type in Road Rage Minnesota, you get stories about road rage. Come on, Dick, I just said you owned I just said you owned an SEO company. Help me out here. I know it's on his timeline. Road Rage Minneapolis. Okay, here we go. Is this a link? No, that's just a picture. Tanner, you're killing me. I think it's the 17th. But yeah. So check that out. Come visit Road Rage Minneapolis, August 17th. Come hang out, share whiskey with me. We're gonna ruin downtown or uptown or something, Minneapolis. Friday night, Saturday all day, and then Saturday evening will be the show, if I understand that correctly. And we will. Road rages are fun. They really are. They're a blast. Lots of great people, lots of camaraderie, and good times are had. So come out, hang out with us. That'd be great. But yeah, Dick will be on Monday. We'll be talking about it. I'm going to go on his show on Sunday, but I think it'll release on Tuesday. So it is the 17th. Thank you, Super Iron Bob. All right, guys. Let's see. Should we jump into this Meyer versus Waid thing? Probably. Where did my document go? Two of these things. Okay. Let's see. We need to have a Rekieta con. If I ever do a Rekieta con, trust me, I'll let you know. And the only reason I do it is because you'll definitely want to come. If I'm throwing a Rekieta con, it'll be worth flying here for. Road Rage is worth flying here for too, but I would bring you something different as well. So this is Richard Meyer, your boy Zach. Here we go. When Motion says, if you are ever at Yellowstone, go to Running Bear Pancake House. It's in West Yellowstone. It's one of the best places to get breakfast in the entire USA. Definitely worth the drive out. Okay. I would love to. What? My phone just buzzed. Oh. Sorry. It's in the wrong place. If my stuff is in the wrong place, my stuff's in the wrong place. I can't do my show. It's like a little bit of my OCD. Okay, so where we left off in Meyer versus Waid. Oh my gosh. Where we left off in Meyer versus Waid was they had a motion to dismiss based on lack of personal jurisdiction over Waid, right? So this is in the Western District of Texas, but it's in federal court because there's diversity of citizenship between the two parties. Meyer's a Texas citizen. Waid is a California citizen or resident or whatever, communist. So Waid's in California, Meyer's in Texas. So when you have diversity of citizenship and you have an amount in controversy over $75,000, which is what's alleged here, then you have diversity of citizenship and federal court has jurisdiction. But you still have to have jurisdiction of the specific court over the defendant. So when you've got Meyer in Texas and Waid in California, the California district that Waid is in has personal jurisdiction over Waid because he lives there. He's in the jurisdiction. He's in the forum. Texas has to extend jurisdiction over, even the federal court in Texas has to extend jurisdiction over Waid through something called a long arm statute. And that basically allows, I think the Texas long arm statute is basically the long arm statute for Texas reaches as far as the federal limits of common law, which is, this is like your first, maybe you're, depending on how your school does, it's like your first or second semester of civil procedure. And it's really fun. It's so much fun to talk about this stuff. But anyway, so they had to extend jurisdiction over Waid. Waid argued that they didn't have jurisdiction over him because he had no expectation to be hailed into court in Texas, which is kind of the legal standard. Would you have expectation to be hailed into court in the forum? Waid says, I didn't know that he was in Texas. So even though it's a Texas company, a Texas contract that he induced breach of, and a Texas party, he said, well, but I didn't know it was Texas, so I shouldn't have to go there. And they worked really hard to make that argument. Ultimately, that failed pretty quickly. And then the other argument was, so that was on the tortious interference with contracts. The magistrate judge recommended that suit move on. But the magistrate judge recommended that the defamation cause of action, actually be dismissed for lack of jurisdiction, because initially in the argument section, Meyer's complaint doesn't specifically state that it's tied to defamatory statements made in Texas. Now, during the deposition of Mark Waid, and actually I think it was before the deposition, it was during jurisdictional discovery, he admitted that he had made statements in Houston, Texas at a comic book panel specifically about Meyer, and those statements were the same as the defamatory statements in the complaint. Now, they argued because they weren't pled in the complaint that they didn't count, and that's not what Meyer's talking about. But Meyer and his counsel clarified that, no, actually, we do mention statements made at panels along with statements made on social media, and so that includes the Texas thing. But we have a solution. We'll just amend the pleadings to make it very clear in the pleadings. So that's what they asked the court to do. Allow us to file our amended complaint. And then Waid opposed it, because if he opposes it, then he wins on the issue. And if he wins on the opposition, he wins on the issue. And then it's dismissed, and it's a big pain, more time and money. That's a lot of setup for this is what happened. Before the court is the above-styled numbered action, which was filed on September 19th, 2018. There are several pending matters in the action. Defendant Mark Waid's motion to dismiss for lack of personal jurisdiction filed November 2nd, 2018. So when I talked about the Weeb Wars, the Mignogna lawsuit slowing down, this is the speed that these lawsuits normally go to. This was filed November 2nd, 2018. They still haven't even filed their motion to dismiss under the TCPA. It's been extended all the way to now because of this jurisdictional argument. So that was November. We're in August. 9 months. 9 months for the motion to dismiss to be resolved. This is how court cases normally go. They take a very long time. There's not a lot of updates between action. There's long periods of quiet. So here we have this. Plaintiff Richard Meyer's response filed April 12th, 2019, and Waid's reply filed April 22nd, 2019, were referred to the United States Magistrate Judge for report and recommendation. On November 29th, 2019, this court granted limited jurisdictional discovery ahead of Meyer's deadline to respond to the motion to dismiss. So now they gave something like 90 days of that limited jurisdictional discovery, and that 90 days, comes after the motions filed on November 2nd, and then all the opposition, the request for jurisdictional discovery happens. So that if you've got a 90-day window, you have like a month on either end for the stuff to still occur. That's why we're at 9 months out here. On June 10th, 2019, the magistrate judge signed a report and recommendation suggesting that the court grant Waid's motion to dismiss in part and dismiss Meyer's defamation claim and deny the motion in part as to the remaining tortious interference claim. The parties received the report and recommendation on June 10th. Objections to the report and recommendation were due to be filed on or before June 24th. Both sides filed objections on June 24th, and both sides filed responses to those objections on July 12th. Catch you later, Ty. Also on June 24th, Meyer filed an opposed motion for leave to file plaintiff's first amended complaint. So he filed he asked the court for permission to file his first amended complaint, to which Waid responded in opposition on July 12th, and Meyer filed a reply on July 23rd. By his motion, so it's important to note that this order was filed on July 24th. So this is one day after Meyer's reply. By his motion regarding the personal jurisdiction issues raised by Waid's motion to dismiss, Meyer contends that any confusion about the nexus between the state of Texas and Meyer's defamation claim can be remedied with the proposed first amended complaint. By pleading the events in a more straightforward manner, Meyer argues the new pleadings will reflect that Waid should have expected no less than to be hailed into Texas court for defaming a Texas resident in Texas. And that is true. That is what he argued. It is the obvious argument, and there should be no burden on filing an amended complaint. But Waid did object to that, and we'll talk about it. Rather than take up the motion to dismiss in the report and recommendation in the first instance, the court addresses Meyer's request to file an amended complaint. Currently, there is no deadline for the parties to file amended pleadings, as the parties have yet to file a proposed scheduling order. So when it looks like you're going to proceed on with a lawsuit, the parties have to get together in conference, often with the judge's clerk, and they set up a conference call and they say, okay, when are the deadlines for this stuff? When is your discovery deadline? When is your dispositive motion deadline? Those are motions to dismiss, or motions that would resolve a case entirely, like summary judgment. When is your non-dispositive motion deadline? What trial date are we shooting for? How much time do you need at trial? What's the pre-trial date? Do we need to schedule alternative dispute resolution, like arbitration or mediation, to happen prior to any of this stuff? You set out in a scheduling order or in a scheduling conference all of this stuff, and then the judge issues an order, and then those deadlines are binding on the parties, barring something happening where they get modified. All right. So neither party has actually filed a proposed scheduling order, and therefore there is no scheduling order in place. So because of that, the judge says, the judge is just noting that for now. So here's a quote from the Federal Rules of Civil Procedure 15A. Leave to amend should be freely given when justice so requires. Waid opposes Meyer's request to file an amended pleading, arguing that Meyer unduly delayed in seeking leave until after the magistrate judge filed the report and recommendation. Further, Waid argues that based on the allegations in the proposed amended complaint, the court would continue to lack personal jurisdiction over Waid, and in any event, Meyer's defamation claim would be time barred. That's a bold claim, because his defamation claim, his amended complaint, isn't actually amending the factual nature of the complaint. He's not adding a new claim. He's not changing the factual scenario. The amended complaint, as it's written, clarifies that it includes the defamatory statements that are made in Texas. So, having considered the case file and applicable law, the court concludes that as the case is in its early stages, and so as to allow inclusion of all parties' claims and defenses, this is judicial efficiency. It's not judicially efficient to separate out a bunch of claims and make people file all over the place. If a court has jurisdiction and it has justiciability over the claims, it's going to take jurisdiction and exercise it. The court will grant Meyer leave to file plaintiff's first amended complaint. In light of allowing Meyer to file an amended complaint and to maintain order with the pleadings and motions, the court will dismiss Waid's motion to dismiss without prejudice. So Waid's motion to dismiss, gone. Poof. Upon considering the first amended complaint, Waid may refile his motion to dismiss if he considers it appropriate. So the court says, well, we're getting rid of your motion to dismiss, mainly because it's moot. The amended complaint moots part of the thing, and they would have to make a new argument about it. So then, so he can refile it if he wants. It is ordered that Plaintiff Richard Meyer's opposed motion for leave to file plaintiff's first amended complaint filed June 24th is granted. The clerk of court is directed to file the proposed plaintiff's first amended complaint. It is further ordered that defendant Mark Waid's motion to dismiss for lack of personal jurisdiction filed November 2nd is dismissed without prejudice. It is further ordered that the parties consult the website for the U.S. District Court of the Western District of Texas, the Forms tab, Austin Division, and submit a joint proposed scheduling order utilizing this court's form on or before Friday, August 23rd. So by August 23rd, they need to have a scheduling order in place, jointly proposed, and that's, then the judge will issue the order. So that's signed by Lee Yackel. Very, very simple order. This next one's a little weird, but clearly, so the answer there is that right now, Meyer's first amended complaint, which we've read through, is the complaint, and Waid has not actually, by function of the court, has not actually moved to dismiss for lack of jurisdiction. So Waid can file another. He could try and file again another motion to dismiss for lack of jurisdiction. But here's the interesting and tricky part of that. TCPA. This is in federal court, but it uses Texas procedural law, and TCPA is a law in Texas, in the jurisdiction. So the anti-SLAPP law for Texas applies. But that means that they have a 60-day window. Now, back when they filed this motion to dismiss, they requested that the court grant them basically 14 days. 14 days from the resolution of the motion to dismiss for lack of jurisdiction to file a TCPA claim. So then, now that that's resolved, they've asked the court for clarification. The court granted clarification on this today. So here it is. Order granting confirmation of deadline to file TCPA motion. On this day came before the court defendant Mark Waid's unopposed motion for confirmation of the deadline to file Texas Citizens Participation Act motion. The court hereby grants defendant's motion for confirmation of the deadline to file TCPA motion. The court's previous order is hereby confirmed, and it is hereby ordered that the deadline is extended such that if the court denies in whole or in part defendant's anticipated motion to dismiss the first amended complaint for lack of personal jurisdiction, defendant would only then need to file any motion under the TCPA within 14 days of the court's order on the jurisdictional motion. This is wordy. For clarity, the 14-day period would not begin to run on a magistrate's report and recommendation, but only on the court's order and that report and recommendation. So now Waid has a dilemma. Waid's dilemma is pretty simple. On July 24th, the order the motion was dismissed. That was done by the court's order. Waid has 14 days from July 24th, 14 days from July 24th to file a TCPA. So they could still file their motion to dismiss based on lack of jurisdiction, but they no longer have an extension for the TCPA. And I think if they asked Meyer for another extension on that so they could do another motion to dismiss, I'm going to guess he's going to say no. If I just had to wager. So 14 days from the 24th is what? It's the 7th, right? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Yeah, it's the 7th of August. So that is next week. We will likely see a TCPA motion to dismiss in Meyer versus Waid. In the same way we've seen one in the Mignogna case, it'll probably be kind of similar, right? Because it's tortious interference with contract and it's defamation, which are two of the claims that have been that are present in the Mignogna case. So we actually should see a little bit less ridiculous procedure going forward through this case, and we should see it pretty soon. So that'll be on the 7th. They will have to file that by the 7th, and then they will have to have a hearing on that within 60 days. So October 7th would be the hearing deadline, assuming there's no more discovery, assuming nothing else happens there. October 7th would be roughly October 7th. It might be October 6th. Because August is 31 days. September's 30. Anyway, it'll be around then. And then Meyer's going to have to respond sometime in there. And then once they have that hearing, they have 30 days to rule on it. So same rules all apply. See, you say it's Mark Zaid and it will be every bit as ridiculous, Siren, but Mark Zaid hasn't done any work on this case. That he's not on any paperwork. He's not on any paperwork in this case. He was only on Twitter and running. It seemed like he was running some social media offense on it, but yeah, he did not. He hasn't really done anything in the case. I'm gonna have some Aberlore here. So yeah, maybe it'll be ridiculous. Maybe Zaid will file some ridiculous stuff, but remains to be seen. So far, it seems to be handled by his much less absurd local counsel. I can't remember that guy's name, but I mean, he seems to at least draft decent documents. Wouldn't it be after the order on the new motion to dismiss on jurisdiction? No. They haven't filed that. And that's not what the order said. There isn't a new motion to dismiss for lack of jurisdiction, and they haven't filed it. And no, the judges are gonna run out of patience on these procedural motions. I think if they filed their motion to dismiss for lack of jurisdiction prior to filing a TCPA, that Meyer's counsel would argue that they're trying to unduly delay the action and run up bills. I think that would be a fair assessment at that point. Stuart Posma says, hey, finally got a break. Love the stream tonight. Please pour one out to the liquor store / bar staff that are getting overclocked due to Big Valley Jamboree. For you, buddy. All right. So that is Meyer versus Waid. Count Camp says, which is worse, $120 super chat or $120 chat or $21 chats? The $21 chats is worse. That's a mess. It's not as easy for me to track them either. You want to see the chair? Here it is. Hey girl, how you doing? Okay. It says anticipated motion. Where does it say anticipated motion? The anticipated motion was in what? This other thing, right? Oh, no. Sorry. I see what's going on. I see why this is confusing. Okay, hold on. They sent this request in a long time ago. Let me see if I can find it. Hold on. Hold on. Okay, here we go. Oh, let me see what this says. I might be incorrect. You might be right. Let me read this real quick. Here's the unopposed motion. Hold on, I just gotta I'll get it downloaded and then I'll pull it up here. We'll go through it. How about that? All right, so here we go. Here's the unopposed motion. Maybe I read that incorrectly or too hastily. That'd be fun. That'd be fun. Okay. Defendant Mark Waid files this unopposed motion for confirmation of the deadline to file TCPA motion. In support thereof shows as follows. Filed a motion to dismiss for lack of personal jurisdiction on November 2nd. Defendant's position is that the lawsuit should be dismissed because the court does not have personal jurisdiction over him. Plaintiff contests defendant's jurisdictional position. TCPA sets out a deadline. Defendant believes that he would have a valid motion under the TCPA if it was found the court does have jurisdiction. As a result, defendant previously filed an unopposed motion to extend the time for filing a motion under the TCPA. Court granted defendant's motion to extend the deadline to file TCPA on November 27th and ordered defendant's TCPA motion would be due within 14 days of the court's order denying in whole or in part the motion to dismiss for lack of personal jurisdiction. On July 24th, the court dismissed without prejudice defendant's motion to dismiss for lack of personal jurisdiction to allow plaintiff to file his amended complaint. In dismissing defendant's motion to dismiss, court noted that defendant may file a motion to dismiss upon... Oh my God. Such a motion is currently due on or before August 7th. Because the court did not rule on the jurisdictional issues, defendant's view is that the court's previous extension remains in effect. However, out of an abundance of caution, defendant submits this motion confirming that the extension remains in place. Because defendant's position is that the court lacks personal jurisdiction, defendant believes the most efficient approach is to confirm the extension of the deadline for any TCPA motion to 14 days after an order by the court deciding the defendant's jurisdictional motion, denying in whole or in part the motion aimed at the first amended complaint. If the court dismisses for lack of jurisdiction, the parties would not need to engage in the expensive motion practice under the TCPA. If the court finds there is jurisdiction, the issue of the TCPA could then be raised and addressed. Because defendant's view is that personal jurisdiction does not exist as the first amended complaint either, defendant plans to file a motion to dismiss the first amended complaint. Because of defendant's plans to urge a jurisdictional challenge, good cause remains. Oh my God. And plaintiff's counsel agreed. All right, I read that wrong. I didn't, I was thinking that this order for clarification was in regards to the original order. And I did not read through this motion. So there you go. You're right. It's the... Oh my God. So they're going to file another motion to dismiss in the next 5 days. Oh boy. They're gonna file another motion to dismiss for lack of jurisdiction in the next 5 days, and then upon losing that motion, which they almost certainly will, like the judge has basically forecast that they're going to lose that. They'll get to file their TCPA motion to dismiss. Whew. All right, what a waste. I'm surprised the plaintiff agreed to that. I would not have agreed to that at all. Wow. Undersigned counsel for defendant has conferred with plaintiff's counsel, and plaintiff does not oppose defendant's request for confirmation of his deadline to file any TCPA motions as sought in this motion. Plaintiff, however, preserves all other defenses and arguments in response to any TCPA motion. I mean, I guess he could still argue that it's untimely, but man, that's That is awful. Hmm. Yes. Okay, so disregard everything I just said about the timeline, because this timeline just got pushed out at a minimum another 30 days, probably. Um. Goodness. Glad you don't have to lead off with that correction on Monday. No kidding. No kidding. Would you come on the Tism next week and make fun of Count Dankula for not having a kid yet? What's the Tism? I don't think it's unreasonable to make them go through the expensive TCPA without a ruling on jurisdiction. I think they should have a limit of time and they should get to choose. The court has basically forecast what's going to happen. I think their arguments are untimely. Untimely. I think the jurisdictional argument was actually crafted to cause delay in the first place. But that's my opinion, you know. So there you go. Who's paying for all that? The Incredible Salt Mine is Tism. Maybe. It depends on, you know, if I'm invited and when it is. Okay. Let's see. What next? What are we gonna do? Is there still more Vic stuff to talk about? I mean, there is more Vic stuff to talk about. Let me see what documents there are in the Vic case that I might need to go through real quick. All this continuance stuff is taken care of. Motion for more time. Supplemental TCPA claim of Funimation. Amendment to affirmative defense. All right. I think we've seen all of the stuff in Mignogna's case. Hold on, out of here for a minute. We've seen all of the documents in Mignogna's case, which means I have a couple options to do here. Ace Attorney. Oh my goodness. I could do Ace Attorney. I wasn't really planning on doing Ace Attorney tonight. What I was going to do is talk more Mignogna. I thought I had more stuff to cover on Mignogna's case. I mean, I've still got... We could take a look at Marchie. Let me real quick take a look at Marky's TCPA filing, and we can take a look at what is strikeable there, because we haven't actually seen it. Hold on. Where do I have this? I mean, I have it. I just have to find out where it is. Oh, this is funny. Do we have any of this stuff? I've also got some stuff you guys still haven't seen. Let me see. Oh, we do need to... We'll talk about the GoFundMe in just a second. I'm skimming through something real quick here. Excuse me. The liquor is hitting my hiccups. Oh, do you want to go? We could do this. This might just be fun. I said this is a chill stream, right? So this is a nice chill topic to go through. I think we have Monica. I think I have her emails hiring the mall cop for her Kamehacon weird thing. That might be kind of funny. I'm trying to find it, just a second here. Oh God, some of this stuff is just great. This is Boomerang, but I'm trying to find it. So. Oh my goodness. Here we go. Security for autograph signing. Here it is. Do you guys want to, is this something you want to see? Is this something you guys want to see real quick? We can do, oh my God, it's like 1,000 degrees in the vault. All the dead air. Hold on, let me open the vault door because I need some airflow. It's brutal. Hopefully that'll help. If I don't open the door, I'm gonna have to thought stream and take my shirt off or whatever. Oh, there it is. There's the cool air coming in. Woohoo! Woohoo! Okay, so in categoristic fashion, they submitted these in reverse order. Let's do it. So we're gonna go up. This is the mall cop. This is the mall cop hiring for. So if you don't remember, Monica Rial definitely didn't threaten to breach her contract with Kamehacon. She definitely did not send an email that says, I can't attend Kamehacon this year. She definitely didn't do that. Like, right, where is it? Right, nope. She definitely didn't do that. Where we go? Not there. So bad at this. So bad at this. Look at this disaster of formatting that they did. Oh my gosh. Run them over with a truck in the nicest way. Culturally appropriate them with the truck of peace in Minecraft. Here we go. She definitely didn't breach her contract with Kamehacon on March 23rd, 2019, like this. Hello, Chris. I have to cancel my appearance at Kamehacon this year. I appreciate your efforts to accommodate, and please know there are no hard feelings. Wishing you and the show all the best. This is how we breach contracts. So she definitely didn't do that. That's not something she did. I remembered the I got the page number. Aha! Smart. Smart this time. Cultural enrichment. Oh, yeah. So here we go. Monica Rial. This is from Monica to John Hindy. Security for autograph signing. Let's find out how she got the most qualified mall cop ever. Hey, what's up, Ethan? How's it going, buddy? I need to DM you. I said I would, and I haven't done it yet. That's on me. Hello, John. Thank you so much for speaking with me this afternoon. As I mentioned, I'm looking for security for a small autograph signing event. I'm doing at Doc's Comics and Games in Frisco, Texas from 12 to 6 on Saturday, April 13th. I think we'll only need 1 or 2 people. I'll have my assistant with me who is also in security. The store isn't huge, but there are 2 entrances. We will have 4 or 5 actors, but they will all be behind stationary tables. Basically, your folks will be hanging out in a comic shop with voice actors all day. Seems like she's selling that. Like, that's a good thing. We will be providing lunch and snacks. Don't worry, Ron's there. We know snacks are coming. Snacks and beverages. Please let me know if this is something you would be interested in and how much it would cost me. Tank Theta says, yo, I want to promote another indies game, Kingdoms of the Dump. I sense a lot of passion with these devs and want to help them shine. They're basically making a new Chrono Trigger-esque game, and they're close to reaching funding. Okay, guys, check out Kingdoms of the Dump. There you go. Here we go. So then John, Director of Operations of Crimson Consulting, LLC. Never above you, never below you, always beside you. That's a great tagline. I love it. Monica, thank you for the call. Sorry for the confusion. It said Brazil was calling, so I thought it was one of my locals. We generally charge $65 per hour for this kind of work, but I'm willing to come down a little to make it more manageable for you. Sorry. I think 2 guys would be fine for that. All of my staff are current or former military spec ops guys or have a law enforcement background. There you go, guys. There you go. Mall cop confirmed. Confirmed legit military spec ops or law enforcement. Pick your poison. Pick your poison. I will run by the shop next week when I'm home and take a look. Let me know what you think. Have fun. RS. John Hindi. I don't know what R even S means. Respectfully and sincerely? Something like that. Monica says, that sounds great, John. Thank you so much. Please check out the shop and let me know what you think. But yeah, I think 2 people will be good. Enjoy the show and talk to you soon. Monica. RS. Okay. Oh, and then he sent immediately another one. Let's see, 304. So 302, he sent nothing, and then 304, he sent something. Unless there's an attachment that they didn't include. Guess that would probably not matter, but... Monica says, I went by the comic shop. I believe 2 is going to be your best option. With multiple entrances and large parking lot on both sides, it would be easier to secure the site if we could control the doors. Do we know if we can secure the back door for talent and staff entrance only? Some of the people there might be qualified to secure the back door without their military training. Or the other way around, but essentially only using 1 door for guests. Let me know what you want to do so we can lock this in and I can put guys on it. I will certainly come by and make sure it's taken care of the right way, but I will not be on site all day. Thank you. Monica says, awesome. Hope you had a blast in Brazil. 2 guys sounds great. I emailed the owner of the shop asking about securing an entrance. I'll let you know as soon as I hear back from him. Monica, I haven't stored your cell phone number. I'm going to give it to the 2 guys working on Saturday, if that's okay. Can you give me that and any other instructions you'd like them to have? Thank you. Uh-oh. I got to make sure this isn't on here. Okay, I already have it redacted. So, okay, good. All right. I just wanted to make sure. I don't want to give out anyone's cell phone. See, I'm not them, right? Giving out Vic's cell phone. Lovely, lovely move of them. Hi, John. I spoke to Murdoch, the store owner, and he said they can't block off an entrance. he did say he could put an employee back there. So don't worry. Okay, think about this from legitimate security concerns, right? Your security professional says, this would be better if we could just block off one of the entrances. And then that way we can focus on having only one point of entry, which would give us security. It would also give them a secure exit, right? A blocked off door that they could maybe make a hastily exit out of that way where there wouldn't be people. And then, sorry, no. And let me tell you why. Probably because the contract for the comic shop, the rental agreement, says that they will have both entrances open during business hours, at all times accessible when during the opening, and they have to maintain that. And that's probably related to a fire code or something. So no, they can't block off the entrance. But don't worry. Rather than having your professional security person, we'll just go ahead and put a comic book store employee. It's fine. It's the same thing. They'll do just great. Just great. Intimidator0108 says, hey, Nick, had a good time with family earlier today at the local golf course for wings and beer. And I have to admit, I'm fishing for compliments, lol. But did you get a chance to watch the race I DM'd you last night? No, I haven't. I didn't have time to turn on YouTube today. All day phone calls. All day. Great. Wonderful. Charles S. says, wait a minute. If this is the clown I think he is, this security guy is a fraud and has been repeatedly debunked. Well, hey, I'm not throwing shade. I'm not throwing shade. You guys have to throw your own shade. So, yeah, okay, so back to this. I spoke to Murdoch, the store owner. Murdoch should be a security guy, right? Like, I trust Murdoch with my life. I just automatically, like, look, I need to hire a security guy. Oh, I'm going to send over Murdoch. Oh my God, I'm safe. Immediately safe because Murdoch is there. I spoke to Murdoch, the store owner, and he said they can't block off an entrance. He did say they can put an employee back there. Just wanted to update you. Also, please let the guys know I'll be providing lunch and drinks. Oh, that's nice. John replies, Monica, I have briefed both Jeff and Mike. They will handle the detail with the utmost professionalism and make sure you're taken care of. Can you give me the contact of your assistant/security person? Thanks. What's the name of what's the mall cop's name? I can't remember the mall cop's name. And yes, I absolutely did watch Josh's phone call with him. Oh, died the entire time. So good. Is that Mike? What's his no, not Paul Blart. Guys. No, the guy. Roser sounds familiar. Why you guys... I'm not talking about the movie Paul Blart Mall Cop. I'm talking about the guy who works security, who called Kiwi Farms up and has threatened to, like, drone strike Josh and all of that stuff. Roser, what's his first name? Jeff Roser. So he's Jeff. Okay, that's it. That's what I'm looking for. Gottfried Roser. Okay. Okay, Jeffrey Allen / Gottfried Roser. Thank you. Thank you to whoever just anonymously texted me that. That's what I was looking for. So that's Jeff. That's Jeff. Definitely spec ops or former law enforcement. And listen, he's a destroyer, and he doesn't know how he's going to handle it. Look, it's just going to be handled. He got called by professionals within the government. It's just going to be handled, okay? I'm not threatening you. I'm just saying you're going to definitely die by Special Force Black Ops, or you'll be extradited you'll have extraordinary rendition to your new prison cell in Jordan, running your little Kiwi farm site. Oh my goodness. Oh. Hold on. Oh my goodness. Okay. All right. So thank you so much. Sorry, this back to Monica's response. Too much fun. Thank you so much. Sure thing. His name is Mike Fritz, and his phone number is blah, and his email is blah. I'll be at the shop at around 11 on Saturday. If you guys need anything before then, please feel free to text and call me at blah. So John Hindi. John Hindi says, Monica, thank you for the opportunity to work with you. So this is April 13th. So this is after the event. That was April 10th. April 13th after the event, 6:56 p.m. Mike told me you were going to pay them directly. In some cases, that's okay, but when security personnel are covered with a license of a company, we have to go through a business. I'll submit an invoice to you. I will pay the guys through the company. Apparently, like his T button is broken whenever he types the. I will invoice 12 to 7 p.m. for Mike and Jeff. The total is $910. Oh, no. Oh, God. What was the number? I think the total number of people coming to that line was 96 by a source that was there counting. 96 people. That means I don't think they out-earned it. They would have to... Oh, wait, no, 96. That's $10 a person on average would have done it. I don't know if they made $10 a person, though, because they were giving some of those for free. Some of those were free. If you have any questions, please let me know. Thank you. Monica says, sorry, John. Yesterday was so busy, I barely even got to speak to the guys until the very end. What's with all the absence of teas? I paid him both $500 cash for their work plus tip. Then both or each? They were amazing, and I'd be happy to work with them again in he future. John, I'm glad you were pleased. They too enjoyed working with you, and I would like to work with you again in the future. Please keep in mind we have guys all over the states, and most of my guys travel as well. Thanks again. Drexel sends similar emails, I hear. Oh my goodness. Okay, so that's those. That's just for fun. I honestly have no idea why that was in the discovery file. I don't think that anything regarding... Maybe they had any communications regarding Kamehacon in the discovery file. I guess that's where that could be. But yeah, let's reread that email and imagine it was Drexel sending it. Glad you were pleased. They too enjoyed working with you, and I would like to work with you again in the future. Please keep in mind we have guys all over. I have stallions all over the states, and most of my stallions travel as well. Squad up. Thanks again. Oh man. Oh. So I don't know about Crimson Consulting or John Hindi at all. But I've read some funny stuff about Jeff Fallon or Gottfried Rosen or whatever his name is. Gottfried. I only hope that everybody out there was that they all had a good time. That's what I hope. Okay, that was just for fun. Someone pointed out that I didn't actually read Volney's letter to the court. Maybe that will be funny to actually read in hindsight. And we can compare that to the outcome of the hearing. That'd be good. Yeah. Oh my gosh. Okay. Have Drexel read it when he comes back on the show. Remind me if I forget. I'll have Drexel read it. And Mark, yeah, we'll do Volney's letter real quick and Marky's TCPA. Most of this is exhibits. So we have just a couple pages of Volney's letter to the judge. So this is a letter leading up to the teleconference hearing that was held yesterday, or, well, Thursday, depending on what time zone you're in. All right, so Dear Judge Chupp, I write on behalf of all defendants to report some progress on narrowing the issues concerning today's 11 a.m. telephonic hearing on plaintiff's motion to continue hearing on TCPA motion to dismiss. Footnote 1. Plaintiff's amended motion to continue correctly identified the defendant's motions to dismiss pursuant to the Texas Citizens Participation Act and their attendant supplements, the TCPA motions. Weird. While the defendants would prefer to move forward with the TCPA motions next week, yesterday we proposed an alternative hearing date that gives plaintiffs 2 additional weeks to respond to the TCPA motions and creates a defined briefing structure. Communications between myself and plaintiff counsel are attached as Exhibit A. Oh, so those are new. New to me. I haven't read them. Assuming the court wants to proceed along this new route, there are a few impasses that require your direction. I have reduced defendant's proposal to a proposed order attached as Exhibit B. Conditional agreements. TCPA motions will be heard on August 22nd from 10 a.m. to 12 p.m. Footnote. This date was selected because Mr. Lemoyne scheduled for a multi-day bench on August 26th. Look, I got a multi-day bench. And then the defendants will share 1 hour and 5 minutes of argument time, and the plaintiff will have 55 minutes of argument to respond, dependent upon court approval. So that's something to bear in mind on this motion practice. Motion hearings, you have a limited amount of time. So they've got 2 hours of motion time, which they're cutely saying that they'll have 105 or an hour and 5 minutes and then 55 minutes. So they've allocated every single moment of the 2 hours between 10 and noon. There's no way that your hearing, your argument starts exactly at 10 and all of that stuff. And there's no delays or anything, but for simplicity's sake, 2 hours of argument. That's it. That's all they're proposing. That all the defendants will make their arguments within 1 hour. Mind you, Funimation included 500 pages of exhibits. So their oral argument, presumably, is limited to 22 minutes. They split it 3 ways. 22 minutes for Funimation Monica and Toye to argue about 500 pages of evidence. And then Ty has 55 minutes, which he'll have to split 3 ways as well, basically. In theory, I mean, if we're doing it that way. So he has even less than 22 minutes to argue about the admissibility. This is their proposal, to argue about the admissibility and the validity of the TCPA in general. Very, very cramped for time. That's not a lot. And judges interrupt your arguments. Like if you stand up to, okay, Your Honor, I have this much time to make my argument. Here it goes. And you start talking and they say, wait, hold on. I got a question. I got another question. Well, what about this? Well, what about this? Can you clarify this for me? It's not just like you get 55 minutes of exposition to just go. You have to break it down. Wouldn't Monica and Ron get half? Not if I'm Funimation, and not if I'm Markey, not if I'm them. I'd say, no. You guys file joint, you argue joint. The impasses. Because the TCPA does not currently provide any statutory guidance in terms of briefing, there are 3 areas of conflict that turn solely on how the court wants to conduct this hearing. 1, when and how evidentiary objections will be addressed. 2, when and how some as yet undisclosed motion plaintiff intends to file will be addressed. And 3, the timing of briefs contesting or in support of the TCPA motions. Footnote 5. Fortunately, the legislature's recently passed HB 2370 effective September 1st, which requires 21-day notice of the hearing and response briefing 7 days before the hearing. I mean, it's sort of fortunate, except that doesn't apply to this action because it's effective September 1st. But either way. Evidentiary objections. Defendant's proposal is by written submission to the court. So defendants propose that all of Ty's objections to various evidence, motions to strike, would be dealt specifically on paper by written submission. Ty's proposal by oral argument to the court prior to the actual argument to the TCPA motions. The court is obviously well versed in applying the Texas rules of evidence both in its trial rulings and summary judgment hearing rulings. Absent some unique evidentiary issue the court may want to hear oral argument on, defendants submit that a multi-hour hearing solely to address evidentiary issues, then followed by the TCPA hearing, unnecessarily complicates the legal issues at play in the TCPA motion. Of course they do. As Funimation pointed out in its opposition to the continuance, whether the TCPA applies is typically decided by plaintiff's pleading, see Hirsch versus Tatum. Whether plaintiff meets his evidentiary burdens as to his 4 claims will turn presumably on his yet unfiled evidence. Affirmative defenses are then decided on defendant's evidence. So again, they have to go ahead and admit that the defendant's evidence does apply, it does matter, beyond just the pleadings. Plaintiff's undisclosed motion. Defendant's proposal is none. Plaintiff's proposal is oral argument on the undisclosed motions to the court prior to the actual argument on the TCPA. So same thing. At this point in time, Ty, of course, does not want to be limited to 1 hour of argument for all of it, for motions to strike and for the motions on the TCPA. That's a lot to cram into an hour. Defendants cannot address an undisclosed motion other than to note that Texas Rule of Civil Procedure 21 typically requires 3 days notice of such hearing. While there is no provision in the TCPA for an undisclosed motion, at least one court of appeals has upheld an objection as to timeliness of ambush response filings in the TCPA context. Defendants are thus opposed to any surprise arguments plaintiff intends to advance, much less requiring those to occur prior to argument on the TCPA motion. So that's footnote 7. Mission Wrecker Services SA Incorporated versus Assured Towing. The absence of a rule directly applicable to an issue should not be used as a means to ambush opposing counsel. Gressman versus Stevens. Instead, in the absence of a rule, the trial court should have the discretion to determine the timeliness of a response. So that's the case partially on point. So then finally, the timing on briefing in relation to the August 22nd hearing. Plaintiff will file his responses. So this is defendant's proposal. Plaintiff will file his response and any evidentiary objections to the TCPA motions by August 16th at 5 p.m. Defendant will file any reply in support of the TCPA motions and evidentiary objections to plaintiff's response by August 20th at 5 p.m. And plaintiff will file any response to defendant's evidentiary objections by August 21st at 5 p.m. Plaintiff's proposal. Plaintiff files his response and any evidentiary objections to the TCPA motions by Monday the 19th. Defendants will file any reply in support of the TCPA motions and evidentiary objections by August 20th. And plaintiff will file any response to defendant's evidentiary objections by August 21st. So just crunching the window for his opposition at that one. Mythos Irving says, Drexel and Mad Black Atheist second stream when? So Susan W, YouTube CEO, can shut your channel down because they hate basketball Americans, clearly lol. I don't know if I'm going to have Mad Black on anytime soon. Apparently, Mad Black's been throwing shade at me, Tug, Hero Hay, and Yellow Flash again. Which he denied doing the first time, but apparently he's doing it now. I don't know. I don't have time. I don't have time to review my own stuff, much less go watch Mad Black's drama channel. So I've gotten a couple DMs and stuff about people talking about what's going on Mad Black's channel. He's going to do him, right? Like, I think that's the most clear thing about Mad Black is he will do what he wants to do. I don't have any problem with Mad Black. If he's got a problem with me, he should probably talk to me about it. He has my contact info, but you know, whatever. I don't really care. Plaintiff's proposal compresses defendant's ability to file a cogent reply, along with any evidentiary objections, to 31 hours as compared to the 96 hours proposed by defendants. Footnote. The 31 hours offered by plaintiff requires defendants to work through the night to take advantage of the full amount of time. Oh, man. This time frame stands in stark contrast to the 15 days and 23 hours plaintiff has to analyze and respond to the TCPA motions if defendants had filed their TCPA motions today at 10 a.m. instead of their actual filing dates. Yeah, but here's the problem. There's not rules on this. And the Texas rules are 3 days. That's not an ambush. You have 3 days. You don't normally get 96 hours to respond. You have 96 hours to hearing. 96 hours to a hearing. Wait, not even. You have 72 hours to a hearing. Why would you get 96 hours to respond and then go to a hearing? Conclusion, defendant's proposal contained in the attached order provides plaintiff with ample time to respond to defendant's TCPA motions and any supplements. And it avoids multiple hearings on evidentiary objections or undisclosed motions while allowing the court sufficient time to review the relevant papers before the August 22nd hearing. Defendants look forward to receiving the court's guidance on these matters. I'm just going to say it. 2 hours is not enough time for this hearing. Period. There's no way, in my opinion, that either side can adequately argue their motion within two hours. Too much evidence is... Now, maybe if a bunch of evidence gets stricken, then sure. Then you could argue it in 2 hours. But currently there's there's something like 980 pages of evidence. How are you going to argue competently on that? Okay, Exhibit A. So here's the... Are these in backwards order? They are, so we'll start at the bottom. All right. So from Ty Beard to everybody. Counsel, here are the phone numbers I have for each of you. Please confirm that your phone number is correct or give me the correct number. If anyone does not want to be on the call, please let me know. Unfortunately, our system won't let me call more than 6 people. Therefore, Andrea or Christian, would you mind dialing in using the dial-in number below? I'll start calling at 10:45 a.m. The instructions are to call Mr. Fisher a few minutes before 11 a.m. and he'll get the judge. In case there's a problem with me calling you or if you get disconnected, below is the conference dial-in information that you can use. There you go. So from John Volney to Ty Beard, Ty and Carrie, in an effort to resolve tomorrow's motion, here's a proposal that all defendants can live with. All 3 anti-SLAPP motions to dismiss will be heard on August 22nd and last from 10 a.m. to 12 p.m. Time allocation will be 1 hour and 5 minutes for defendants, 55 minutes for plaintiff. All evidentiary objections will be decided by submission. Plaintiff will file his response and any evidentiary objections to the motion to dismiss by August 16th. We just read this. Is this acceptable to you? Thanks for letting me know. So this is from Ty. This is July 31st at 4:36 p.m. Just 24 minutes later. Hey, John, I appreciate your efforts to resolve this issue amicably. Here's what we are willing to agree to. So then that was the Ty's counter proposal that John laid out in the tables. Ty, thank you for the response. This is progress, but the timetable you propose is too compressed for us. We cannot agree to a pre-TCPA motion hearing on evidentiary objections or other motions you may file that we don't know about. Here's all the same. Here's their updated thing. I think all defendants are on board with this proposal. If anyone is not, let us know, please. And then Ty says, John, we will not agree to any particular time limit on our evidentiary objections and motions to strike. We don't agree to the August filing 16 deadline, but can agree to moving the hearing out another couple of days so that your deadlines aren't overly cramped. So Ty offered to move the deadlines out from August 22nd a couple days. But then, of course, they didn't resolve this issue at close of business, and they had the phone call the next morning and apparently couldn't get it resolved. So John filed this and asked the court so the court would have record of it and the court could see where they were going. And then again, in light of this, the court gave them until September 6th. Something to consider. This is something that doesn't seem to be taken into account here. In light of the fact that Ty was willing to go August 22nd, maybe August 24th, if we say a couple days, right? We can move it out a couple days to give them more time. The court granted not just August 29th, but September 6th. They gave them a full extra week. Now, that was because Lemoyne apparently has trial on the 29th and can't commit to it. But the court could have moved it forward. The court could have moved it back a day or something like that, but they didn't. They gave him a full extra week. If you think that Ty isn't actually winning these hearings, you've got to look at the results. I think Law Twitter would do well to look at these results. Look at what was proposed and what came out of it. They proposed a 2-week extension. Ty proposed a 3-week extension. Ty got a 4-week extension. If defendants think that they're in good... I mean, Law Twitter might think defendants are in good graces with the judge and the judge really loves them. They may think that and the judge hates Ty. I doubt defendants' counsel thinks that. I highly doubt it. So you can imagine that John Volney submitted this. So Lemoyne is opposing the continuance outright or are advocating in the alternative for Volney's position. Volney's advocating for it. Ty ends up advocating, no, we want the 29th. We want our initial request. Because you don't come to a resolution, then like just because you might have come to a resolution doesn't mean that suddenly you've compromised your initial request. Their initial request was the 29th. And they got more. If I were the defense, again, if I were the defendants, I would be looking at 4 hearings now. Ty has walked out of there with, at worst, what he wanted. At worst, he's gotten what he was after. At best, he's gotten more. In at least 3, if not all 4 of those hearings. Defense counsel has to be looking, and again, Law Twitter, they're occasionally reading a transcript of these hearings and determining based on some bias that Ty is wrong and that the judge hates him and is making fun of him and all that stuff. It doesn't matter. Ty doesn't care. I don't care. They have to consider that Ty is getting what he's asking for or more from the judge in 4 out of 4 hearings. And trust me, no matter what Law Twitter thinks or any outside observer thinks, the defense attorneys are going, we keep going in there and we keep walking out holding our nuts on a platter. Why do you think Volney is proposing to have the evidentiary motions to strike heard on paper rather than at oral argument? Why is that? Maybe it's because they keep losing hearings. Ty was on yesterday. I love hearings. I'll go down to the courthouse all the time. Ty loves to go down to the courthouse and do a hearing. It's where he prefers to be. Apparently, John doesn't want that. I can see why. They keep getting manhandled, keep getting surprised by the country bumpkin lawyer, doesn't know what he's doing, and then shows up and just wins. All right, let's pull up Markey's TCPA. I think I read through it. I have it somewhere, but I think it's on my other computer. Oh my goodness. Yawnsplaining the wokeness. Here we go. HB. Oh, wait, no. Will K says, no self-respecting spec ops nor law enforcement would do this kind of work, not unless they got booted or fired for being effing POS. Dude is probably a stolen valor cuck. Oh, God. Man, if I'm former spec ops doing security, it better be for more than 65 an hour. That's all I'm saying. Viatoro7 says, shout out to my friend Will Lucas and his girlfriend. Currently, they are being detained in a Malaysian airport for not having their passports stamped coming in. Please contact your senators and congresspeople to bring them back. Oh my goodness. Is that a news story somewhere? That's amazing. HB says 2 hours for the whole shebang. Are they trying to squeeze Ty for time, or is someone running out of money and credit? No, they're trying to squeeze Ty for time. Right? Oh, in 2 hours he can argue all of his evidentiary stuff. Well, the judge can... Here's the 2 hour thing. If they have 2 hours, the judge can rule on the paper submissions for all of the... He can rule on paper submissions for all of the evidentiary motions. That's fine. We don't need to argue about those. The judge is competent to handle those, and we don't need to talk to him about it. Now, I have heard from Ty that the judge has preserved oral argument, that he will read all of the submitted paperwork that's filed in time, but that he has preserved oral argument on any of the evidentiary issues. So any of the motions to strike will have oral argument time. $65 an hour for both? Oh my God. Yeah, you're right. I didn't math that in my head. Wait. No. What is that? It's 7 times 65 is... No, 7 times 65 is 455. It's 65 an hour each. Yeah, it's 65 an hour each. Still, and yes, the company's going to take their cut of that. That's just not enough money. That's not enough money. Plus, you have to be in the same room as Monica Rial and Ron Toye for 7 hours. Would you guys do that for 65 an hour? Oh my gosh, I wouldn't. 50 an hour might be $100,000, but that's assuming you get your 2,080 hours. That's assuming full time. Like lawyer hourly rates, 500 an hour or whatever. The lawyer's not billing 2,080 hours most of the time. Unless they work for the NRA, then they're billing like 2,000 hours a day. Did you guys see that? I'm looking into it more, but a guy I've had on the show, Stephen Gutowski, he's the Second Amendment journalist for the Washington Free Beacon. He retweeted a story about the NRA. There's some allegations about the NRA's lawyers. At one point, the NRA's law firm was billing $97,000 a day. A day. So think about that. Let's say, now the lawyers I believe are in Dallas. Let's say, are they in Dallas? I feel like they are. But again, let's say your rate, and this is an extremely high rate. Now, they get higher. Specialty lawyers who are highly regarded can make a ton of money. Like their hourly rate can be off the charts. But let's say your rate is $1,000 an hour, and that's averaging your lawyers, your legal assistants, and your paralegals. That's everything. $1,000 an hour average across the firm services portfolio, which is unrealistically huge. At that rate, they're doing 97 hours of work a day. A day. So that means that they have 12 people running an 8-hour shift per day at $1,000 an hour. If anyone is confused about maybe the impropriety of that, I think that deserves an audit, personally. I think that deserves an audit. You've got 12 staff full-time for full 8 hours at $1,000 an hour for 8 hours per day, multiple days. Don't buy it. I don't buy it at all. What is that law firm doing for the NRA that is worth that astronomical amount of money? Very curious. Very curious. You don't do 97 hours of work a day. You have 97 work hours a day. So again, that's 12 people averaging $1,000 an hour per day. That means, I guess in theory, you could have your senior partner could have $2,500 an hour, and then your paralegal could have something like, $100 an hour. That averages out to 1,000-ish, a little bit more, but. Why do you hate freedom? I love freedom. I don't think the NRA is for freedom at all. I don't think the NRA has been about preserving the meaning of the Second Amendment for a very long time. All right, defendant Jamie Markey's motion to dismiss pursuant to the Texas Citizens Participation Act. What are we doing here? We're going to go through the evidence, their attached evidence, right? Because they have the Declaration of Markey. Why? Why can't they put it in portrait? Wrong with these people. Preservation of evidence. TDMA. And a bunch of tweets. Then the deposition. Hold on. I'm skimming. I'm reading all of this right now. Trying to see if there's anything else. Deposition of Vic. All right. Trying to figure out the best way to do this. Because we could go through the document itself. I think really it's just about looking at the declaration of Jamie Markey. And any attached stuff. So let's do that. Okay. So here we go. It's probably a bad idea. Yeah, we'll strike out hearsay, legal conclusions, and anything that's not established. And that's not everything. Of course, Markey will be attacked on her credibility in all of this. Hey, do you guys know that Jamie Markey was the writing director on a show back in 2015, and they decided to go ahead and put a line in about Gamergate in the English dub of the Japanese cartoon that wasn't talking about Gamergate. And I don't know if Markey herself authorized it, but someone on the team did. And then when called on it, Funimation went into a panic, but Markey and her writing partner doubled down and engaged people on Twitter. Yet again, another instance of someone who works for Funimation telling their customers that they are awful people. Good job. Great job. We have the best employees, folks. Really tremendous. Terrific. Have you seen her hair? It's fabulous. Fabulous hair from Jamie Markey. She likes to use hun. Hey hun, how you doing? Hey, but really a snake. An absolute snake. Oh, and I've also heard rumblings that Markey's husband might be interested in punching me in the face. Marky's husband. I hope you're tall enough to reach, my friend. I hope you're tall enough to reach. What was the other thing I was going to say about that? Oh, maybe you guys can help me out with this. Can someone help me out? Maybe you can, maybe you can't. It's 2015 that this happens. Marky and, what's his name? I've got his name here. Hold on. Marky and Tyson Reinhardt. Tyson Reinhardt was the junior writer on that show. They're the ones who engaged in the Twitter fight. In the Twitter fight with customers, right? If anybody out there is bored and can DM me or whatever, what I have heard about that is that Marky and Reinhardt were going hard at people, and then at the same time immediately stop. Immediately stop. I think that's very interesting. Because if they, at the same time, in the middle of the controversy, both immediately stopped, what does that sound like? Does it sound like maybe Funimation exerted control over the social media accounts of its employees? Or, contractors? I think it kind of does. So if anyone's bored and likes to look into that kind of stuff, that would be really helpful. What was the other thing I was going to ask? I was going to ask the chat. Oh, one more thing for the chat. I know at the beginning of the Broly Blu-ray release that Funimation did not include the advertised special feature of Vic doing some sort of commentary, right? There's some Vic special feature that was supposed to be on the Blu-ray and it wasn't. Can anyone he does not work at the Tuttle Group. No, he doesn't. Can anyone tell me, did Vic's special feature ever make it onto the Blu-ray? Or is it still gone? And is it still advertised on the box? That's what I would like to know. Spell Reinhardt or the true spelling. I think it's Reinhardt. I think. It was never included. It was never included. Was not on the Blu-ray. It was removed and still advertised. Oh, it's Reinhardt? Tyson Reinhardt. There you go. Thank you. Yeah, that Blu-ray thing has me real interested. So do you know what? I don't know if you guys know this, but there's a person in charge. Hold on, let me do this. There's a person in charge of Blu-ray special features. You guys know that? Funimation has a dedicated person. Let's see. There's a staff member dedicated to that. It's not Sabbath. It's not Sabbath. I'll tell you who does it. And you may be disappointed in this. I know many of you actually will. But there's a person. And she already features in this story. Her name is Colleen Klinkenbeard. So Colleen Klinkenbeard, Let me read you an email from Monica Rial to Trina Simon. Trina Simon is the HR person at Funimation. I don't know if you guys have seen this either. Here we go. Hello, Trina. My name is Monica Rial, and I'm a contract voice actor for Funimation. As you know, one of Funimation's other voice actors, Vic Mignogna, was accused of sexual assault, harassment and assault. I am one of his accusers. He assaulted me in 2007, harassed me since the early 2000s. This was sent on February 7th, all right? When was this sent? When was this sent? February 7th? When was that? That's well after. That's well after the termination of Vic Mignogna. This is not part of the investigation. Trina Simon is the only HR person at Funimation. Let me repeat that. Trina Simon, the only HR person at Funimation, is getting a report from Monica Rial about harassment in the workplace on February 7th. And the way she's writing it, I have to assume she's never heard about this. I shared my story with investigators. An investigator. Because although it is well past the statute of limitations, it would corroborate other testimony. I posted an image on Twitter saying something to the effect of, I support victims. Several of my friends also posted messages of support. Due to this outpouring of support, VIX fans started viciously attacking my friends and me. We have received death threats online and via text, see below, and now bizarre phone calls. I have now received 3 phone calls. At 4:50 p.m. today, February 7th, I received a call from Sean Schemmel. Or at least it appeared that way. His name was definitely on the screen, but when I answered it, was the deep voice of an African-American man. He said, "Yo, why you keep calling me?" I laughed, thinking maybe Sean was doing an impression or something. Sean do black voices to you all the time, Monica? And how do you identify black voices? Then the voice said, "You're a liar. You're a liar. And I don't effing like liars." I laughed out of nervousness and I questioned, "Sean, what?" Then the voice said, "Why you laughing? You ain't gonna be laughing for long." I sat in silence for a moment, then hung up. So apparently he was correct. She ain't gonna be laughing for long. That had to happen. That was accurate. I then texted Sean, see text image below, and subsequently called him and learned that he had received a call from my number asking about drugs, which he joked about and laughed off. I contacted Colleen Klinkenbeard. Why? Didn't Kara Edwards talk to Colleen Klinkenbeard too? Who in turn contacted Justin Cook and Karen Mika. The experience, on top of all the threats, scared me. I'm scared because obviously somebody found my phone number on the internet, and since I'm a homeowner, my address is public record. I'm afraid for my safety. I was told to contact you, and I began writing this email on February 7th. While working on it, I received 2 more phone calls, one that appeared to be from my brother, Miguel Rial, and the other from Colleen Klinkenbeard. The first call had the same recorded message as the earlier call. The second call had a new message from another voice calling themselves Putin, but it sounded to be pre-recorded as well. Oh my God! Pre-recorded! It's a prank call. It's a prank call service that does this. Ah! No! No! I've gotten that call. I just thought about it. It's been like a year. I've gotten the black guy threat call. I got it. The funny thing about that call for me is I'm an attorney. So at first I was like, whatever, buddy. Did you get arrested or something? Can I help you? Oh no. Oh no. A new message from another voice. God, what's the Putin one? Tell me it is like this. Tell me it is Russian. Tell me Putin will help you out. Listen, okay, I got polonium for you. We have to really be cautious, you know, because we got lots of polonium and very, very unsafe for you to go outside, okay? Be careful, you stay inside, I warn you. What is this? Come on. I filed a report with the Richardson Police Department, the city where I live, and that report, she got a prank. She identifies that it's a pre-recorded call, and she calls the police. Oh, God. The attending officer is Officer Shakora Bunting, and her email is shakorabunting@cor.gov. I understand this will probably be written off as internet bullying and pranks. That's because it is a prank. But I am legitimately concerned for my safety. I'm being blamed for this man's removal from companies, even though he was... Listen to this, Funimation. Even though he was fired as a result of internal investigations. I feel as though Funimation is more concerned with my assaulter's safety than mine. My fiance has been very vocal on Twitter and is gathering any evidence of threats made against me. Please understand that he is concerned for my safety as well as that of his son who lives with us. Vic has continually been vocal on the app Unlocked and on his website, the Risen Bull Rangers. He has asked his fans to attack his detractors. He is responsible for this attack on me and my colleagues. For all I know, he could have given them my phone number. His supporters have also been sharing pictures of my friend Jamie McGonigal, his husband, and his young son, which makes me incredibly nervous for them. I was asked to give you a call tonight, but I only have your office number. Please feel free to reach out to me at blank. Thank you, Monica Rial. So here's comments on YouTube comments. Notice these aren't readable at all. Oh wait, here's the Schemmel one. What was that about? I just got a call from your number. Was that you? If so, it was an amazing impression because it didn't sound anything like you. I just got a call from you that sounded like a black dude talking to me and it wasn't an impression of you. What the hell's going on? Yeah, me too. What the F was that? Probably Sabbath, Monica. I've heard Sabbath likes to prank people. Maybe even Sean Schemmel. Can you do a Russian Lemoyne? Okay. Okay. We will talk like Lemoyne in Russian for a little bit. It's okay. We have... Look, in Soviet Russia, TCPA screws you. I hope that's good. I hope that's good. So, you know, we've got the clear racism. Sounded like a black man. How dare they? How dare they? Oh, then this guy. This is going to make other VAs reconsider going to cons if people keep trying to do this. English non-canon VA Bulma is a feminist, by the way. Non-canon VA, her English VA just defended DBZ from feminazi and burned around, or it turned around and pulls this. She defended the show from a feminist because it's her paycheck. She threw Vic under the bus because it makes her look good. She has no honor. She's in it for herself. She's a selfish, see you next Tuesday. If she got fired, she would do a 360. Look at that threat. Look at that threat. Look at the harassment somewhere not to Monica. It's important to note that these things are not to Monica. Harassment is not, I went out and found people talking bad about me. That's not harassment. That's not harassment ever. Let's see. Here's all this stuff. Here's all this stuff. Good God. What are all these arrows doing? Even trying to say. All right. Anyway, that's that. I thought you guys might find this interesting because the HR department right here, the HR department at Funimation was apparently not contacted by Monica Rial about the sexual harassment and assault of Vic Mignogna until after he was fired. Apparently. I don't know if that's true. This is weirdly worded email. Hi Trina, my name is Monica Rial. You don't know me. You haven't just dealt with this issue. All right. Sorry. Found it very interesting. This Colleen Klinkenbeard thing is very interesting. Oh yeah, let me put it all together for you. Monica Rial contacts Colleen Klinkenbeard. Okay. Kara Edwards contacts Colleen Klinkenbeard. Okay. Karen Klinkenbeard removes Vic's special feature from the Blu-ray. Does that sound like a conspiracy? Does that... I mean, I'm not saying that's conclusive proof of a conspiracy, but it kind of looks like Colleen Klinkenbeard acting as an employee of Funimation, definitely an employee of Funimation, is contacted by Kara Edwards and Monica Rial. Most importantly, Monica Rial, but also Kara Edwards of Funimation here. That seems a little... That's kind of looks like evidence of a conspiracy between two of the defendants to me. Okay. On to Jamie's thing here. Oh, wait. Matt Field says, when Charlton Heston said his famous quote, from my cold dead hands, he was holding a muzzle-loading rifle. A muzzle-loaded rifle, pistol, musket, cannon is not a firearm per U.S. law. WTF are they protecting again? F the NRA. So there you go. My name is Jamie Markey. I'm an adult over the age of 18 years and am physically and mentally competent. We got to go ahead and strike that one. To testify to the matters set forth in this declaration. I'm a voice actor and writer primarily in the anime industry. In approximately 2011, I was in the lobby of Funimation Production LLC's building where I was a voice actor at the time. I saw plaintiff Victor Mignogna and said hello. Plaintiff walked over to me and we gave each other a hug, which is a relatively common greeting among voice actors who've worked together before. An uncommon greeting, though, is what plaintiff did next. Listen, Sweet Cheeks, can I call you Sweet Cheeks? Can I condescend you a little more? The greeting happened with the hug. The next thing is not a greeting. The next thing after the hug is no longer the greeting. Just being a little critical here. While still standing in the Funimation lobby, plaintiff started running his fingers through my hair. This behavior made me uncomfortable, but I did not object verbally because I thought it would end as quickly as it began. When plaintiff's hands reached the roots of my hair across the back of my head, he splayed his fingers and moved his hand to the base of my skull, then clenched his hand into a fist. In so doing, plaintiff grabbed my hair close to the root and then jerked his fist, which abruptly, unexpectedly, and painfully yanked my head backwards. Plaintiff then leaned slightly in. Just slightly, though. Having already taken control of my head, pressed his lips to my ear before whispering a sexual statement to me. Listen, she's a writer, right? She's a writer. Remember this. She's a writer. I do not recall the specific words he said, but I know with certainty they were of a sexual nature directed at me. Not sure that she can make that claim. I felt hopeless, out of control of my own body, and grossly intimidated by plaintiff's unwanted and uninvited contact and words imposed upon me. I'm a writer. Sorry, that's an old joke. After escaping his grasp, I was shocked and stunned by what had just happened. Jamie, you're a writer. Get rid of the to be verbs here. I escaped his grasp, shocked and stunned by what had just happened. Get rid of the was. Come on. She's not a very good writer. I felt unsafe at my own workplace. I nevertheless dismissed the experience without reporting it to Funimation. Plaintiff is widely known in the anime world, has a loyal and broad following of fans, and on top of that, he was one of the most ubiquitous voice actors on the convention circuit. Might have to question the use of ubiquitous, but maybe. I did not feel that I could go up against plaintiff with a wide public persona and vast fan base and still have my career survive. This is interesting. These are probably not hearsay, but they imply hearsay. They imply that she is told that he's widely known. But it's probably evidence of the character of the reputation of the plaintiff or something. That's weird. That's a weird one. Question to the ladies in the chat. How many of you like having your hair grabbed and pulled back a little bit? By someone you trust, of course. By someone you trust. I know I do. I love it when I grab my own hair and pull my hair back. Kind of hard. My hair's short. My hair's short. That's a joke. That's a joke. In early 2019, women began coming out with the truth about their various experiences with plaintiff. That's hearsay. I mean, literally trying to assert the truth of the matter right there. Something I'd heard of or read for many years before from various women. That's part of the hearsay. Good job. I realized then that my experience was not unique, and I made the brave decision. She calls herself brave. Come on. Come on. Come on. To publicly state the truth about what plaintiff did to me. I thus wrote a statement via Twitter on February 8th so that other women who were victims of plaintiff or other aggressors would know they are not alone and that they could stand up for themselves and speak out, and to confirm for all of us that our bodies are our own and only we can decide what is done with them. You know what's interesting? This isn't hearsay. This is cool. Someone said lawyer wrote this. Yeah. Here's why. Look at this statement. This is credit to Sam. Credit to Sam. This is a well-drafted statement. This statement would be hearsay if it was offered to prove the truth of what happened. I thus wrote a statement via Twitter on February 8th so that other women who are victims of so that other women would know that this happened. Boom, hearsay. Because you can't offer your own statement. But They wrote the statement for a different purpose and state the alternative purpose. So they're not trying to prove the truth of the statement. They're trying to prove this truth here, that they did this. Probably not hearsay. Very, very well done. Good job. Good job, Sam. A true and correct copy of my Twitter statement is attached here to as Exhibit A1. I was the only author of my statement, and I still believe it was important to post as a means of showing solidarity and empathy with plaintiffs and other aggressors' other victims. Since telling the truth about what plaintiff did to me, I have been harassed, threatened, and lambasted by an army of in-person and online trolls at plaintiff's and his attorney's bidding. Well, I mean, not really. Despite the danger to my life and my family, I am steadfast in the need to speak the truth. I have not made these statements out of malice. This is a legal conclusion. Or any desire to hurt plaintiff. Strike. I admittedly felt and still feel anger toward plaintiff and hurt at what he made me endure. And I hope his life experiences will teach him to behave differently. But my intent in my outcry was always to provide an opportunity for healing and encouragement. This is a legal conclusion as well. Intent is a matter of fact to be resolved by a finder of fact. Intent in defamation, especially in regards to malice, is a fact question. Strike those. I did not communicate with Funimation Productions LLC regarding plaintiff while it was investigating allegations about his conduct prior to terminating his contracts. Likewise, I did not reach out to any convention or other production company to discuss plaintiff or encourage either expressly or implicitly to reduce or terminate their business dealings with him as a result of the allegations against him. This actually might be hearsay. So if you want to offer a party statement as non-hearsay, an outside of court party statement as non-hearsay, then you have to do that. You have to offer the other party, like it's an opposition statement offered, or it's a statement adverse to their interests. So this is a self-serving hearsay statement because she says, I did not reach out to any convention. So there's the statement or the lack of statement or production company to discuss plaintiff or encourage either expressly or implicitly to reduce or terminate their business dealings. So the statement is being offered for the purposes of proving the truth that she didn't do this. That's hearsay. Attached here to as Exhibit A2 and A3 are true and correct copies of correspondence I received from plaintiff. Ooh. My name is Jamie Markey. My date of birth is October 8th, 1977. And my address is 9411 Timberleaf Drive, Dallas, Texas. I figured I've doxed her enough on accident that I'll just dox her now. It's a joke. It's not a dox. It's been released publicly several times as a public document. Shane Holmberg was the first person to release Jamie Markey's address. Not me. Not me. That's a joke. Executed in Dallas County, state of Texas. Blah, 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 blah. Exhibit A1. So here's her. Here's her thing. So she said this was a true and correct copy. A1. A1 steak sauce. Where's that? A true and correct copy of my Twitter statement is attached here to as Exhibit A1. That's likely authenticated. It does have a date on it. Good job. Again, I do think a lawyer wrote that. I do think a lawyer wrote this one. And then these are the things. Now her statement is sort of consistent. It's sort of consistent with her testimony. It'd be hard to impeach it. But some of this might actually be able to be struck. Let's see. In the lobby at my job when I was approached by a coworker. The guy gave me the creeps already. He gave almost all the women at my job the creeps, hearsay. But I always felt like I had to be nice to him anyway because of how revered he was in the industry. As we said hello, notice this is different. In the new one, she mentions the hug. In this one, she does not. he stood to the side of me and started running his fingers through my hair. Now, I do work in an affectionate industry. We hug a lot, and on occasion, we will give a kiss on the cheek. But even, this is actually helpful for Vic. This statement right here is helpful for Vic. But even for an affectionate environment, this felt off. I didn't say anything to him about it, though. It was just his fingers in my hair. I didn't think it was a big deal. At that point, he splayed his fingers, put his hand at the base of my skull, and made a fist. When he did this, he grabbed my hair close to the root, effectively preventing me from moving my head at all. He then jerked his fist, yanking my head backwards and towards him, and whispered something. Something. Something by Calvin Klein into my ear. I don't remember what he said specifically, but I do remember it being sexual in nature. This was not normal. This was not just a hug or a kiss on the cheek. I did not like it. I have no memory of getting out of his grasp, but I assume what the F are you doing was part of my technique. You assume that? You don't have any Okay. Come on now. Come on. Can I rotate this? Can I rotate? Oh, baby, we can rotate it a couple times. I don't want to add notes. Is this a snack tray? I don't want that. Deleted. Deleted. Afterwards, I completely and utterly dismissed this experience. I dismissed the way I had been touched. I dismissed having this man grab me. I dismissed having my head jerked back. I dismissed the inappropriate comment. I dismissed this entire encounter. Did you? I mean, of course, this doesn't actually help her. That she dismissed it. Doesn't help her. That hurts her a little bit. I never reported this event to the company. It actually didn't even occur to me that I should have. That's a bad statement. Although, if it had occurred to me, I can't say I would have reported him. That's a bad statement. The guy was worshipped by his fans. He was worshipped by the studios because of his fans. He was the most popular voice actor on the convention circuit. These are interesting. These probably imply hearsay, but I'm not gonna make the argument for it. If Ty and Bullock want to do that, they can do that. Everyone treated him with kid gloves because he was the one and only Vic Mignogna. Who was I? God, a writer wrote this. Okay, she wrote this. Like, you can tell. Who was I? A nobody in comparison. It's an essay, right? I didn't matter, and I knew it. Risking being blacklisted from my working conventions simply wouldn't have been worth it. As I look back on this moment and discuss it with my family and friends, this isn't helping her either. I can see that his actions qualify as simple assault. That is a legal conclusion. Would he have gone to jail had I pressed charges? I'm not sure. Why would people believe me over a man who holds Bible studies in hotel lobbies? That's right, you atheist harlot. You horrific beast coming out of the waters or whatever. And even if they did, would they care about the truth if that meant tarnishing the reputation of their favorite voice actor? These are weird statements. Very weird. In the last week or so, I've heard accounts of him doing this exact thing over a dozen to half a dozen other women that I personally know. All right, that's hearsay. Why do you think that this wasn't included in the affidavit? I am friends with these women, and we never told each other about our experiences. Well, no. Okay, sorry. I was gonna say that was hearsay, but it's not being used to assert the truth. Some dismissed it, like me. Others felt too ashamed or scared to say anything. That's hearsay. I struggle with the guilt I feel for having been so dismissive of his actions. Had I been able to speak up then, maybe less women would have had to experience what happened when they were unable to get out of Vic's grasp. That is probably hearsay. I would contest this statement. I don't know if you win on it, but I'd contest it anyway. That's insanity. I'm going to have to unrotate it. Well, it doesn't rotate just the page. It rotates the whole document. Oh, how awful is that? Sorry. I'm speaking up now because I didn't even think about this event until I realized other women had experienced the same thing. That is hearsay. I thought it was just me. And at first, I didn't want to say anything because my experience was not nearly as bad as what other people have suffered at the hands of this man. I wanted their stories to be heard first because they were in the important ones. Might be hearsay. But in this moment, I want the others who I know are out there to hear this. It wasn't just you. That's hearsay. I don't know if they fight on all this, right? I don't actually, I'm identifying statements that I think they could possibly challenge. I'm not saying that they're great statements to challenge, just laying it out there. It's okay if you didn't say anything to him or anyone else. You are not responsible for what happened. You do not have to be dismissive, ashamed, and afraid. Also, I hope if anyone ever goes through a similar experience, they will know from the start that their body is not up for debate. Actually, no, your body is up for debate. That's not your body, fam. Oh, yeah, it is. Oh, no, it isn't. What is your body being up for debate? Like, what even is that line? Vic leaned in and whispered, I have information that leads to the arrest of Hillary Clinton. And now we know. Now we know. That's what he really whispered to Jamie Markey. Now we know why he's out. Their body is not property of the most popular person in the room. Their body is not responsible for a company or a show or an art form. Their body is most definitely not responsible for the reputation and livelihood of a predator. You go after that, of course. Nova Zero says, sweet cheeks implies that you think their cheeks are desirable or tempting of a kiss. You lost the case again, Nick. Next time, try Hagmuff. It's more correct. For 100K, could you do a reading of My Immortal? My Immortal. Cheers. I don't know. Maybe. All right, let's see. Rotate clockwise. So that's a statement. Here's the Beard Harris, Bullock and Hughes stuff. It would be hard to go after. I mean, obviously they've authenticated. Like when they provide this, they've basically authenticated the tweet. And now she authenticated it as well. They've authenticated this tweet. Oh, hey, this is interesting. So Beard Harris, Bullock and Hughes identified some of the problems. He gave almost all the women at my job the creeps. That they're identifying defamatory statements. Because he was one and only Vic Mignogna. That's interesting. His actions qualify as simple assault. That's per se defamation. Why would people believe me over a man who holds Bible studies in hotel lobbies? Half a dozen other women that I personally know. Calling her out for lying. Unable to get out of Vic's grasp. That's defamation. Their body is most definitely not responsible for the reputation and livelihood of a predator. Defamation. What would Jesus do? Light him on fire and send him to hell. Were you... This is a Baptist, right? That's a joke. That's a joke. Want his head and I want him to suffer for what he did to my friend, not just her. See, these tweets, these have to go. Can't authenticate them. Don't know the author of them. Don't know anything. That's got to go. Markey's tweet can be included, right? It's time to get angry. It's time to stand up. It's time to let our rage motivate us into making a change. Fighting back does not in any way, shape, or form make me as bad as Vic. That logic is why only 1 out of 3 victims come forward. Exhibit B. This is the deposition. We're not going to go through the deposition. That's just, again, that's just too much. So that's it. I mean, I'm not going to go through this thing again. I demand that they strike their mean words. In the conclusions, I demand that they strike gone of and when after yet no it costs and key because it makes me sad. Makes me sad that they said, go away, Nick. I don't want it in there. I never talked GoFundMe. Oh my gosh, let me bring up the GoFundMe real quick. Sorry. We have broken 236,236,045. Thank you guys for supporting Vic through the GoFundMe. Very awesome. Recent donations: Teresa Bernes, Anerbon Bose, Anonymous, Kevin Kirkpatrick, Anonymous, Jonathan Wiseman, and Anonymous. Thank you all for continuing to support Vic. It means a ton. If you are watching, I really appreciate it. Or if you see this later, that's great. Remember that Vic's GoFundMe is out there, still growing. I know it's a lull period. I mean, if Ty and Vic win at TCPA, I mean, I'm gonna have to do like just a straight laughing / shilling the GoFundMe stream. Just be like the GoFundMe and me laughing for like an hour. We'll see. When is Jamie getting deposed? Jamie won't be deposed until after this TCPA stuff is sorted out. Probably. There you go, guys. It was higher earlier. Oh, something probably got refunded. GoFundMe is not a fan of the joke names. But, all right. Let's go ahead and read through the rest of these chats. And then I think we'll wrap it up. I am going to do some Twitch tonight. I'm going to Twitch thought it up. Press 1 for tank top. That's a joke. Press 2 to stay in my stupid shirt, you boomer. Let's see. All right, so Mercenary X says, well, here we go again. I did not receive a single notification of any kind that you were on, and I missed a lot. So I have to ask to secure myself up. Did you see Court just a tryouts to Electric Boogaloo? Also, yes, I saw the video. No. No, I didn't. Knight of Hopex says, everybody hold up your respirators in honor of Jadolf Lemoyne, destroyer of lungs, gasper of gases, sprayer of eardrums. You were there for us when we were at our lowest point, ready to convert oxygen and give us laughs at your expense. What a friggin' hero. Mercenary X says, holy crap, the dog is eating rocks like the giant in the Neverending Story. Seriously, what is he turning into? A freaking dragon. Next, you know you're gonna need a virgin sacrifice of a princess to satisfy him. Good thing you have T-cell for that. T-cell there for that. What? I don't know what that even means. That dog is eating rocks. Kay says, do you have any pets, Nick? If so, can you dox them and show them on stream? Just some kittens. And no, I can't show them on stream because they're not in the house. I'll show them sometime, just not tonight. Jay says, any tips on how to live in someone's head to such a degree that they frivolously include you in court filings as the puppet Führer asking for a friend? It takes a lot of work. Let's see. Skunk Ghost says, I haven't forgotten, Nick. I remember what you did to me. I'm going to haunt you and spray the poop out of all your clothes. Rude. Mercenary X says, this is my third message. I just wanted sure that the Streamlabs sent the first one. I like Spider-Gwen, but I hate the comic. It wasn't bad at first, but they made Daredevil as a leader of an evil ninja clan, and then Trump and Captain America. God-awful execution. Mercenary X says, oh, poop. Sorry, Nick. Streamlabs is sending my money to you instead of Razor Fist. I apologize for the epic boomer moment and have his money. Don't know why, but Streamlabs is sending money to you. Sorry, Razor. It's mine. It's all mine. And that got sent 3 times. I don't know what happened there, Mercenary, but I'll take it. Tough Luck says the biggest twist in this case turned out to be that Monica is a cuck queen. Books Games Pottery says, I like having my hair pulled a little bit. One of my favorite things, to be honest. Since you asked, lol. I found that. In my unofficial survey, I found that to be true more than I expected. More than I expected. And yeah, I just walk around to random women and ask them if they like to have their hair pulled. Why not, right? What's the benefit of having a YouTube channel if you don't do stuff like that? TLJ Screwjob says, so how do Monica and Jamie not put hearsay? Like Stan, just say facts, facts, facts. This is what happened. This didn't happen. Not, I've heard stuff in the past week, like Jamie. Yeah, very important. Very important to just put facts down. Not what you heard someone else say about something. Hold on. Yeah, I've been sent confirmation that Jack Bishop, Marky's partner, is Marky's husband. Well, not husband though, but fiance is a junior partner of the Tuttle Group. So there you go. Thanks for that. You know who you are. You know who you are. Unknown says, I love how all these defendants leave out the fact that they brought the matter into the public sphere and subjected Vic to months of defamatory comments without any accountability. Power and entitlement indeed. Kay says, in every filing they are writing as though they are trying to win the case in that filing and not trying to advance their side of the suit a step at a time. Do they realize that the 37th time they restate their epic story won't be any better than the first? And each one of those restatements has potential to be inconsistent. Mad Lad says, if you rearrange the letters of Monica Rial, you get, I'm a con liar. It was in her name the whole time. Cynic in Chief says, Tug and Bug Raid. Lucian Sabata Darkness says, just checking, have we lost the case today yet? Oh, yeah, several times. Ishaelson says, where do you find these schmucks always screaming at you? This new one is some twatty 8-year-old. At least he doesn't use an anime avatar. Wink. Well, he doesn't use an anime avatar. He just used he was using a Lord of the Rings avatar, right? But he's not anymore. Matt Rosenfield says, you should get Lemoyne on stream sometime so we can understand the defense's side. We'll be good, honest. I don't know if I believe you. No way would Lemoyne come on this show. I gotta send him an email, right? I have to. Maxwell Kim says, are you going to cover the Epstein trial? Hey, what up, Max? Where you been, fam? Yeah, probably. RM was here, says, is Mars Girl haunted by the ghost of Jew Wario? Yes. But so are all of the children Jew Wario. Marty Lund says, speaking of Colleen, Monica, and DVD extras, remember the special edition Blu-ray box of Full Metal Panic 4 I showed you and Ty at Matsuri? The one release in March with the only character page ruined in the English art book was Vic's character. There you go. I don't know if Klinkenbeard's involved in that. Maybe she is. Corey Wahlberg says, first super chat from a country-loving, gun-toting fellow gamer in Minnesota. Guys like you, Nick, are our blood and pride of the USA. Keep trucking. Oh, man! Sounds like we should hang out, Corey. Tarapar says, sugar-free Milos taste like soap to me. Well, drink some soap then. You must like it. How can you disgrace the real Milo sugarcane tea like that? How? Sad face. Also, hi. Hope all is good. You know, I normally, 99% of the time, I prefer real sugar, especially cane sugar, to anything. I don't like artificial sweeteners. On Milos, I like the sugar-free more than the sweet. The one says, Google giveth, Google taketh away. Austin Hartless says, Discord has private video chats with screen sharing. I know it does, but it puts both. There's no way to do the switching face. Like, no one realizes I want to stream this. Thomas Gabriel White says, can you get Ben Shapiro on the show? Highly unlikely. I'd love it. That'd be a great show. I'd get more viewers than probably ever before. But really, I don't think Ben would come on. He's welcome to. Saxon 85, we'd have to listen to it at half speed, of course. Saxon 85 says, hey, first time here, me and the wife love your stuff. She is a victim of this stuff, and she says this is all BS and Vic should win this. Hey, awesome. Thank you. Thank you so much, and I'm sorry your wife had to go through that. Real Spider Phantom says, crap, now I have to actually watch because the important people are in the chat. Just kidding, kinda. Sorry, Nick. Hey. Don't worry about it. Corollas Rex 1708 says, will there be a chance sooner or later for Mars Girl's deposition, or is that up in the air? Mars Girl's deposition is not beyond her arm's reach. How's that? By the way, let me just suggest, I'll suggest this. If Ty gets past TCPA, do you think the Yost twins aren't going to get deposed? And do you think the Yost twins' depositions aren't going to be broadcast live? Do you think Colleen Klinkenbeard might get deposed? Or Tammy Denbo? Hey, Sony and Funimation. Do you think that your executives are not going to have their depositions broadcast to the entire earth? And do you think that people won't watch? I bet they watch. I bet a lot of people want to see that. Because I tell you what, I can't wait to see. I can't wait to see Funimation's executives deposed. I can't wait to see a Sony HR executive deposed. You guys remember what I said back in the beginning about having a Texas attorney with a belt buckle the size of a satellite dish walk in and ask you questions? Now listen here, Tammy. Why don't you tell me what you did that day? Now you did it to screw over Vic, didn't you? You talked to Monica in advance, didn't you? Could you imagine? That's just this case. What else did they ask about? How many investigations have you done? How many men have you cleared of investigations? How many women have you investigated for sexual harassment? How many women has Sony investigated for sexual harassment? How many women has Funimation investigated for sexual harassment? How did you find out about Sarah Breckmeyer? How did you find out about the Yost twins? How many times did you speak to Monica? What did you say to Monica Rial on the phone? I can't wait. I can't wait. If he gets past TCPA, guess where you'll see those depositions? Guess where they're going to show? I actually have no confirmation of this. I just have a gut feeling that those deposition videos will find their way onto the magic of YouTube. All right. Sorry. Scott Bartlett says, first time viewers, and so far I am enjoying the show. Hey, great. Welcome to it. Blaine 20 says, Ty has freaking lasers in the chat. Probably shouldn't have made him a mod. DCV Titan says, you say citation needed. I say, B words, be lying. Gothic Nerd Chick says, hey, Nick, I sent you an email 2 weeks ago. If you get a chance, please respond. I know you're swamped. I'd attend Rekieta Con, special guest Drexel, and Snack Cucks. Oh, man. That'd be great. Canis Lupus Alpha says, your drink, what is that? You drink it every night. Milo's sweet tea. This is Milo's no-calorie sweet tea. Just like it. Spaslin says, Spaslin. Finally made it to watch the stream live. It's about 6:30 a.m. here in Denmark, and I just got home from a night shift. Give him hell, Nick. Oh, by the way, if any of you guys are from the Netherlands, and might have connections for a job, I'm looking for a friend. I'm looking for job recommendations or connections in the Netherlands for a friend, probably in the IT space. So if you got anything, please shoot me an email. That's a personal request. Finfrog says, I'm late but not dead or pregnant. That's good. Lindsay says, I've been watching all of your deposition videos on the Vic thing, and I got to show my support. You, sir, are a treasure. Keep up the good work. Hey, thank you. Professor Richard Face says, Miles Luna from Rooster Teeth got doxxed today along with 1,999 other journalists. Addresses, emails, and phone numbers. Oh, that's a shame, isn't it? God, I feel so bad. I feel so bad for those journos. Joseph Kerwin says, apparently E3 just leaked 2,000 journos docs. Oof. Well, I know one website that won't take that down. Let's see. Micah Curtis says, does Zayd do anything aside from virtue signal on Twitter? He fights the government. He shouldn't be in this case. It's not really purpose at all. Also, appreciate the kind words about my comic. Let me know if you want to discuss it. I do, Micah. I do want to discuss it. The only hiccup I've had is that this case has gone from 0 to 1,000 over the past couple days. I expect it to slow down sometime soon. But yeah, so hopefully I can do some other shows really soon. Bad Vibe says, congrats, Umbrella family, on the tiniest additional. Hey, congrats, Tug! David Leva says, Nick, why you pee-pee? I have to. Blaine 20 says, you lost Meyer's case, Nick? Your boy's going to be so mad. Hopefully he'll admonish me. Walesy1 says, can you do a TLDR on the Vic case? You know, people have asked me to do that. I think I will. Maybe over this weekend I can put together an adequate recap video of just where the case is. 10 minutes, 15 minutes, or whatever. What's happened in the case to bring us to here. I think a condensed video might be good. I haven't done one in a long time. Maybe I will. SM Scorks 89 says, you did not read Volney's letter to Chup. I have now, though. Austin Hartless says, Monica wants to secure 2 guys on the back door. Oh, my. Oh, my. Tassia says, Nick, I thought you said that this was her ad for security, not her negotiation for more bulls. I'm sick of your grifting ways. Be gone, thought. Mike Lombardo says, DHS letter rackets. Lol. No, the DHS letter. Nah. Gawker's Death Rattle says, Boomer versus Gen X versus Millennial test. Murdoch is A, Daredevil, B, Howling Mad, or C, Gorillas. Blaine 20. I mean, I have to say Howling Mad, right? Blaine 20 says, making huge overtures to keep up the pretense that I Stand With Vic is dangerous was worth every Benjamin lost. Ike 13D says, what do you call a missing T? Absentee. Kunder says, Spec Ops, the land whale is beached in the building. I repeat, the land whale is beached in the building. Land whale is beached in the building. I repeat, land whale is beached in the building. Over. Although she won't turn over. Too heavy. Bob Oxide says, E3 supposedly docks roughly 2,000 people saw on Memology. My wife watches with me, enjoying your rants and analyzing. Love the show. Thanks for what you do. Hey, thanks for watching. It's Kaki Onsai, or thanks your wife, I guess. It's Kaki Onsai says, so what you're saying is that Yahoos like Martin Bessick, Half-Baked, and Mike Dumfrick are arguing the wrong way. They don't seem to have a clue. Of course they're arguing the wrong way. No Clue says, just throwing it out there, the dev of Ooblets is a massive see you next Tuesday, and anyone supporting her on Patreon should rethink their pledge to her. I don't know what Ooblets is. Lane 20 says, I work with cops and security all the time. I also know a former Delta who does security. People talking out of their orifice. Well, how much does former Delta Force get paid to do security? Viatoro 7 says, local Texas news has a story. Just Google ABC 13 Will Lucas. That Cooper fellow says, hey, Nick, E3 apparently accidentally doxed over 2,000 journos. It's on a single site, lol. Nice job, ESA. No one important says, really? First, Miss Kobayashi and now prison school, and then fighting for it? Someone needs to fire/demote Marky. Leave your politics out of my anime. SM Skorks 89 says, the Vic Q&A video that was supposed to be on the DBS Broly Blu-ray can be found on IGN. NixX says, Nick, when you get a chance, look up any clip of Rugrats with Grandpa Boris to hear a certain mosquito-bitten attorney. George Lopez says, all gun control laws are unconstitutional. I'm with it. Professor Azriel says, my new nickname for Ty is One Punch Beard because he always wins. Pray for my wife's labor. We are almost there. Only 3 weeks until my kid is here. Hey, congrats, man. Congrats. It's great. It's great. Things will be great. Father Mazga says, careful, Nick. If you bust this thing open, they'll send a Bitcoin assassin after you. Terrapar says, we need to check whether or not the files for Vic are even on the disk. If they are but inaccessible, that might be more insulting, shady either way. Joshua Moolman says, I'm seriously getting so tired of these lies. Esme Illis Anime says, Cot, damn it, Nick, another kinky stream. Blow dryer needed. You were also missed. Heart. Hey, thanks. Darian the Ghoul says, from what I noticed with these affidavits, they always mention their career and reputation. Wouldn't he have ruined their rep when they denied him sexual favors if they were true, if he was the type? Maybe. Blaine 20 says, sent you a pic of Colleen sitting on Vic's lap and surrounding tweets on Discord DM. Is that Colleen Klinkenbeard? Can someone confirm? Is that Colleen Klinkenbeard on Vic's lap? Hold on, here. Is that her? I guess I could. Oh man, that does look like her, doesn't it? Oh, that's funny. I'll show you why that's funny. Let me pull up why that's funny. Oh, he didn't include it, but someone, I saw this thread earlier, and someone said that that girl was underage. And then someone calls out, I'm sure she'd be flattered to hear you call her under 18, but you're very wrong, and also looking at an out-of-context screenshot. The next person says, she's dang near 40, but good try. That's Colleen Klinkenbeard. She's a fellow voice actress and was at least 33 when this event happened. Next time, do some proper research before you start accusing people, you effing moron, lol. But that's how this thing's gone, right? Oh, they're probably underage. How do you know? How do you know they're underage? Did you ask? Did you ask the age? All the time, what's the answer? No. Well, I didn't ask the age. They looked underage. All right. It comes in Pints, Games, and More says, you know, I find it funny that they attack Vic's Risen Bull Rangers, but nobody has ever said a word about Travis Willingham's miniskirt army. Blaine 20 says, I think they're all just mad that they don't have fan clubs. What's the real narwhals? Like, is that her fan club? Blaine 20 says, L. Jaws Mantello put up a poll asking which of the 3 TCPA stories wins the creep factor. Vic Locks, Techo 7 and 10, or Twincest Proposition. Too bad her snogging and humping 15-year-olds isn't an option. Well, you know, the winning of the creep factor is just her Adam's apple. Josh Sharf says, if Vic has so much power over all these people, Vic has so much... Let's see, what is this? If Vic has so much power over all these people, how did he get easily fired and blackballed by almost everyone in the industry? It's a good question, right? That's a good question. Raider J says, Marky's husband is on the Tuttle website. Ben Frog says, delicious hearsay chocolate bars. Thank you for that Marky's husband thing. That's great. I'll have to pass that on to a certain law firm. Sound of one hand clapping says, check it. Jack Bishop, Marky's significant other, works for Tuttle. Blaine 20 says, so Jamie saying something about Ron and Jack being management could be reread with Tuttle Group in mind. Hascrack says, was a bit bored and decided to submit an open records request for that report. Was tempted to ask for a paper copy to be picked up at RPD for the lulz. Dad Erga says, hi Nick, fellow Minnesotan, just got back from a week in the BWCA and I see Vic and the rest of us are still caught up in Clown World. Maybe we want to stay up there. Anyway, keep on keeping on, sir. Hey, thanks, buddy. Thanks for from and to a fellow Minnesotan. Super Captain Chris says, I know I'm later and less hetero than when Nick starts his streams, but what in the blue F is a TCPA? That's an anti-slap motion in a lawsuit. It's a motion to dismiss based on protected speech. The acronym is Texas Citizens Participation Act, and that is the motion that has been filed by all of the defendants in Vic's case. Lane 20 said, many security companies pay a little more for LEO and COs. Spec Ops is hard to prove, though. The ones I've run across take lower pay because PTSD prevents usual jobs. Fluffy Side Up says, if Vic's commentary isn't on Broly, but is still advertised in the box, could Funny be subject to a lawsuit based on false advertisement? Maybe. Eggs Benedict says, hey Nick, sent a DM of a guy at Nick Rekieta, but the wrong spelling of Rekieta, spreading a fake GoFundMe in your name saying you're setting up a charity MMA fight with Soye. Just a heads up. Oh man. You know, it's not me, but I'll take it. Let's do it, Ron. Let's do it. Let's do it. I'll diet however much I have to get down to your 120-pound weight class. Whatever it takes. Whatever it takes. I'll chain vomit for days to do that fight with you. Asia Frazier says, KV should work at bars because they'd never forget to card. We've got... Let's see. Nice says, I heard hugging was okay in Funimation a long time ago, but since has been frowned upon by management. I'm not sure who management is. Also, this somehow doesn't contradict Marky's story. Night of Hopex says, hey, if you guys want to hurt Funimation beyond just supporting Vic, please consider using White Rabbit Express to buy your anime directly from Japan. I think a lot of it has subtitles in multiple regions these days anyways. And finally, Blaine20 says, scan Jamie's 2015 tweets. No sign of fighting at all. Could have deleted everything on order or wrong year. Could be. I don't know. All right, guys. I'm going to play the outro. We're right at 2 a.m. It was a perfectly executed stream. I'm like a professional or something. Turn this down. I will be on Twitch tonight. You got to give me a few minutes to go get set up. Maybe grab some munchies or something. What else do I want to say? Oh, Flitzy says, have you realized how a bunch of pedo bears are trying to accuse Vic of being one despite a lack of evidence? Oh, yeah. Yeah. The irony is not lost. Irony is not lost. All right, guys. It's Nick the Knife Rekieta, guys. That's my fighting name. All right. Thank you, Larry Blindner, for Nick the Knife. Thanks for joining me tonight. I'm going to go... I think I have to go get changed into my tank top. Should be stupid. And play something on Twitch. Thanks for hanging out. I appreciate it. As always, there probably will not be a stream tomorrow or Sunday unless something weird comes up or I line up a impromptu interview. So look for a stream on Monday, where again we'll have Dick Masterson. We'll be talking about Road Rage, Minneapolis. We'll be talking about Vic from a SEO, marketing, PR perspective through the lens of Dick Masterson. So should be fun time. All right, guys. Thanks for joining me today. Esme Illis Anime says, get Josh Moon. I like his laugh. I'll get Josh on the stream sometime soon. I'm sure we have something to talk about. We always do, and I love talking to Josh. So, all right, guys. Peace. Peace.
From the wide shores of Nairn to the hills of Glenlivet, there's no one who explains the thought better than